Hey, I don't know if I'm live. I'm getting a glitch from StreamYard. All right. I think I'm live now. Let's try it. Welcome, everybody. Welcome to the Law of Self-Defense. I never had that glitch before. Welcome to the Law of Self-Defense and our ongoing coverage of the Alec Baldwin manslaughter trial. I'm so pleased you all can be here again today. I am, of course, Attorney Andrew Branca for the Law of Self-Defense, and we are covering this trial bumper to bumper, as they say. It's been great fun so far. I expect it'll continue to be great. Court's not intended to start for quite some time. I think the jurors were not told to arrive in court until an hour from now, 9:30 a.m. local time, New Mexico time. I'm not sure if the judge has stuff she plans to be doing. In fact, I guess I should see if there's a court stream up, right? Let's see. Where is I've been using Reuters. Some news last night that that's not live though. Well, Reuters has a Facebook page. Who uses Facebook? Okay. No offense, folks. Send this link to myself on my other computer. So, some news last night that it appears the state is going to call Halyna Hutchins to testify today. Hannah has been saying through her attorney, Jason Bowles, her trial attorney, who was terrible, and for some reason is still her attorney. Hannah has been saying she plans to plead the fifth. She doesn't want to answer any questions. She's appealing her conviction. She was, of course, convicted earlier this year on involuntary manslaughter for her role in the death of Halyna Hutchins. She's appealing her conviction, and she doesn't want anything she says in court to be used against her if she were to win a new trial, for example. And if she wins a new trial, it could be. It's just a do-over. The state has tried to offer her generalized use immunity, whereby they could not use anything she says in this trial in her testimony against her should she win a retrial, which is very unlikely. And they wanted that given to her ahead of time by the judge as kind of a blanket immunity. Once you have immunity, you have no Fifth Amendment privilege not to testify. Your Fifth Amendment privilege is to not incriminate yourself. But if you can't be tried for what you say, you can't incriminate yourself. Also, there are lots of questions someone could be asked that are not incriminatory in nature that you would be obliged to answer, despite your Fifth Amendment right. Now, the judge declined to give a pretrial grant of generalized use immunity, so they're going to bring her in and see what happens, I guess. Some judges would say, if I know this witness is planning to plead the fifth, I'm just not going to put him on the witness stand. I'm not going to have him go through that circus, that theater in front of the jury. But here, there are some questions that could be asked. Like, for example, whether Baldwin was attentive at the gun safety training that Hannah provided. That doesn't incriminate Hannah. She should be compelled to answer that question. So I guess we'll see what happens when she comes up. She may say the Fifth Amendment to everything. They did try to interview her just before this trial. And basically she said, I plead the fifth to every question, which isn't really allowed. But there wasn't a judge present for that interview. So there's obviously a judge present here in court. But the jury's not back till 9:30, so I'm not sure if the judge is planning to talk through some of these issues before the jury comes in. If the court goes live, we will of course pop in. So today's day 3, part 1, the morning. As I've done on other days, I'll do a separate morning and afternoon live stream, and then a summary live stream this evening, 40 minutes, an hour, where I go over some of the high points of the day. If Hannah were to plead the fifth and the judge decides that's not proper and orders her to testify and she still refuses, the judge could hold her in contempt of court. So what would that mean? Normally, that means the judge can throw you into jail for a certain period of time or until you comply. It can be a very lengthy period of time. But of course, Hannah's already in prison. So it would be interesting to see how that plays out. The main reason I wanted all of you to come in here today was so I could talk about the jury instructions. But before doing that, I think we need a little history on jury instructions so we can understand how outrageous the defense is actually being here. So back in the day, long before even I began practicing law, jury instructions were essentially drafted de novo, fresh, for every criminal trial. So it's not like jury instructions had not been used before. They're used in every criminal trial. The jury needs to be instructed on the law. But there were no standardized jury instructions. So there was no official set of jury instructions. When it got to the end of the trial, the state would draft some jury instructions, and the jury instructions are essentially an amalgamation of statutory language and case law. So statutory language and how the appellate courts have said they want those statutes to be applied to the facts of a case. So the state would research the statutes and then research the case law that applies those statutes and draft up a set of jury instructions. And, there's wiggle room in there, exactly how you draft them. So naturally, you would expect the state to draft the jury instructions in a way that favors the state, theoretically consistent with the statutory law, consistent with the case law, but to the extent it could be biased slightly in favor of a conviction. And then the defense would draft their own jury instructions. They would look at the statutes. They would look at the case law. And presumably they would draft a set of jury instructions that was biased in favor of a verdict of not guilty. And then the judge would take these two competing sets of jury instructions and decide, all right, this is the final draft. This is what I believe is a correct and proper presentation of the law instructions to the jury. The trouble with that approach is that you ended up with a highly varied set, well, at least a somewhat varied set of jury instructions from case to case. You could have assume exactly identical criminal cases. In one case, a judge might choose the state version of the jury instructions that favors a guilty verdict. And another identical trial, that judge may choose the defense jury instructions that favors a not guilty verdict. And you end up having essentially identical fact cases with very different verdict results. It doesn't feel like due process of law. So what every state has done is establish a set of standardized, sometimes called pattern jury instructions. And I'm going to generalize here because different states do it in different ways, but a common approach is the state Supreme Court, because this falls within the realm of the judiciary, right? The jury instructions happen in the court setting. The state Supreme Court typically establishes a panel of experts, and these experts would be judges. These experts would be prosecutors and defense attorneys and law professors, academics. And this group would work for months, have meetings and do research and have paralegals assisting them and all this stuff. And they would work to come up with a set of standardized jury instructions that everybody more or less agrees on. And these are the exact instructions that are supposed to be used in every case that covers whatever issues that jury instruction covers. So there's one standardized involuntary manslaughter jury instruction. That's it. It's not unique for every case. There's one. Now, for all jury instructions, there's always a little bit of customization that has to happen. It tends to be kind of a fill in the blanks kind of format. In fact, we're going to do a little legal research today, folks. I've got my Lexis pulled up. So let's take a look here, see if I can make this legible for everybody. So here's New Mexico's involuntary manslaughter statute, 14-231. New Mexico, let's see, what do they call it? Yeah, uniform jury instructions. Uniform, standardized, pattern. Okay, these are the official jury instructions, and they have the stamp of approval of the New Mexico Supreme Court. Effectively, the New Mexico Supreme Court is saying, these are the jury instructions I want you to use, period. Don't vary from these. The easiest way for a judge to get reversed on appeal is to screw around with the jury instructions, to diverge from the jury instructions. So, because then they're explicitly disobeying the New Mexico Supreme Court, which obviously is the Supreme Court of New Mexico. Now, every jury instruction requires some customization. You can see it here. They come in kind of a fill in the blanks form. Anybody remember ad libs from when you were kids? Driving to Florida in the station wagon? So you have to fill in things like the name of the defendant, the name of the victim, the date it occurred, right? But that's not a substantive modification of the jury instruction. That's just filling in the facts that are relevant for each particular case. What they don't like is when you substantively change the language of the jury instruction. Guess what the defense is doing here? And what the state's not doing. So I have a little well, it's not really PowerPoint slides. PowerPoints don't work very well in StreamYard. But I have, I'll have to make myself small for this, I guess. Oh, that's too bad. That's hard to read, right? Darn it. My editors are going to get so mad at me. If I do it this way, it's easier to read. All right. So I just want to compare and contrast the official New Mexico jury instruction. That's the same thing we were just looking at. So everything I'm showing you is either drawn from Lexis, the official legal database of New Mexico jury instructions, or the filings by the parties, because I want to compare and contrast those. So this is the involuntary manslaughter statute. Just fill in the blanks. For you to find, the jury, to find the defendant guilty of involuntary manslaughter as charged in count whatever, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. Now, how would this be filled in for this case? That Alec Baldwin, and then you would describe his acts. And the amount of specificity varies. So here, at the minimum, you'd have to say he, engaged in reckless conduct with a firearm, right? Or you could be more specific. You could say here, the facts could say he pointed what he knew to be a real gun at Halyna Hutchins, and he cocked the hammer and he pulled the trigger. That's the claimed reckless conduct. Then number two, and these are cumulative, of course. Number two, Alec Baldwin should have known of the danger involved by Alec Baldwin's conduct. Alec Baldwin acted with willful disregard for the safety of others. Alec Baldwin's act caused the death of Halyna Hutchins. This happened in New Mexico on October 21st, 2021. That's how you would expect this to be, fill in the blanks, to happen in this case, based on the facts of this case. So what did the state do? What's their proposed jury instruction? And I've underlined that they're on the right now. So the official blank, fill in the blank form is on the left. The state's is on the right. And I've underlined where they filled in the blanks. Theirs reads, the defendant, Alexander Baldwin, endangered the safety of another by handling or using a firearm in a reckless manner. Okay, that's the claimed conduct, right? The defendant, Alexander Baldwin, should have known of the danger involved by Alexander Baldwin's actions. The defendant, Alexander Baldwin, acted with a willful disregard for the safety of others. Alexander Baldwin's act caused the death of Halyna Hutchins. This happened in New Mexico on or about the 21st day of October, 2021. So it's just about perfect, right? This is exactly how the official jury instruction is supposed to be used. And this is what the prosecution, has proposed to the judge. Now, again, here is the fill in the blanks, the official version. Let's take a look at what let's take a look at what the defense wants the judge to instruct. I can't fit it on one side of the screen, so I had to give it its own slide. All this underlined stuff is what the defense is filling into the blanks. All of it. Alec Baldwin, for some reason they don't want to use Alexander, through a purposeful and volitional act. Is that in the standard jury instruction? Does it say anywhere in here purposeful and volitional? Nope. Through a purposeful and volitional act, committed the unlawful act of negligent use of a deadly weapon while rehearsing a scene during the production of a movie. Just a fantasy world, right? Right? We do things that appear dangerous in movies all the time, but it's not reality, ladies and gentlemen of the jury. Alec Baldwin should have known of the danger involved from his actions. And then they added, to find that Alec Baldwin should have known of the danger, you must find that he had a subjective knowledge of the danger or risk to others posed by his actions. Is that in the official jury instruction? I don't see that. 3, Alec Baldwin acted with willful disregard for the safety of others. Okay. And then they add all of this. To find that Alec Baldwin acted with willful disregard, you must find that his conduct was more than merely negligent or careless. Rather, you must find that he consciously disregarded a substantial and justifiable risk of harm to others. A substantial and unjustifiable risk is one that any law-abiding person would recognize under similar circumstances, and that would cause any law-abiding person to behave differently than Alec Baldwin out of concern for the safety of others. Further, to find that Alec Baldwin acted with willful disregard, you must find that he was subjectively aware of the risk caused by his conduct and continued to act. Again, this subjective awareness, this purposeful and volitional language, nowhere in the official jury instruction. And I have to pause now because they are, in fact, in the courtroom. Sorry, folks, I'll have to come back to the jury instructions. I thought I left myself plenty of time. So the point is, you can see to what extent the defense is modifying the standard jury instructions in a way that very much is not happening with the state. And when I get a chance to come back to the jury instructions, we'll take a look at how often the phrase purposeful and volitional, or purposeful or volitional, occurs in New Mexico law in the context of involuntary manslaughter. You think it's common? Oh, let me see. They faded out again. Maybe I have a little more time. So they do this again with the alternative count of involuntary manslaughter without due caution or circumspection. So remember, there's two paths to involuntary manslaughter. One is predicated on misdemeanor negligent handling of a firearm. The other one is predicated on failure to use due caution or circumspection when handling the gun. Negligence and recklessness defined is another jury instruction. So this is the standard jury instruction for negligence and recklessness defined. For you to find that the defendant recklessly, in this case, must be acted recklessly. They have a typo, I guess. You must find that the defendant acted with willful disregard of the rights or safety of others and in a manner which endangered any person or property. So that's the standard New Mexico jury instruction for recklessness for our purposes. Here's what the state proposes. For you to find that the defendant acted recklessly in this case, you must find that the defendant acted with willful disregard of the rights or safety of others and in a manner which endangered any person or property. Well, that's the same, right? That's the same. What did the defense want here? For you to find that the defendant committed an act as defined under the first element of involuntary manslaughter, you must find that the state has proved to your satisfaction beyond a reasonable doubt that the act was committed purposefully and volitionally. I underline that. I don't believe they have that underlined in the defense proposed jury instruction, but clearly this purposefully and volitionally language is not in the standard jury instruction. It's just not there. Now, let's do a little thought experiment. Let's go back to Lexis. And I have here all New Mexico cases. So this would be appellate cases. This is the case law, right? Court of Appeals and New Mexico Supreme Court. And let's take a look. Here's the search window. Let me put in purposefully or volitionally within 20 characters of involuntary manslaughter. This is the entire history of New Mexico case law. Has the word purposefully or volitionally ever been used in New Mexico case law in the context of involuntary manslaughter? Never. Never. Never in the entire history of New Mexico law. Never been done. Never been done. I think that's going to be a little awkward when it comes to argument before this judge on the inclusion of this language. Now, is it required that there was some intentional conduct by Alec Baldwin? Of course. Otherwise, this would be a legitimate accident. Accident in the legal sense of the term, that he had zero contribution to what happened. If the set had fallen on Alec Baldwin, and that's what made him discharge the gun, that would be a legitimate argument. What caused the gun to fire was completely outside any reasonable person's control if the set collapsed on them. So there has to be some intentional act that created the unjustified risk of death or serious bodily injury to Halyna Hutchins. The recklessness, that's a required prerequisite for involuntary manslaughter. And that is, of course, that he pointed what he knew to be a real gun at Halyna Hutchins. He cocked the hammer. He pressed the trigger without ensuring there was real ammo in the gun. That is the intentional conduct. What's not required for involuntary manslaughter is that he intended the outcome. Then it would be an intentional killing. All right, folks, we're back in the courtroom. There's no volume. The parties are there. Alexandra, Hooters Hancock. So she was on direct yesterday. She'll be continuing her. I don't think they were done with direct. I think direct was still ongoing. Direct was pretty boring. I'm not getting any volume. Did I not put the
side issue that I've asked Mr. Nick is to address the court on the motion?
Okay,
this is
fine.
just a quick, and if it takes out of our time, it does. But I get many sort of inbound emails that I don't obviously read everyone or take everyone seriously, but I got one last night that indicated that the cameras are catching Miss Morrissey signaling witnesses while they're on the witness stand. And you know, I really
Did you look to see if that was true?
I was sent a photograph that concerned me, and I felt obligated, and like I said to the court, I try to not make.
He's bringing an internet rumor he did not verify to the court's attention.
Case. I've been in many. There have been more issues in this case than I have ever seen in all of those cases combined, and so I'm sort of at a loss, but to bring it to the court's attention. So I've asked them to print me the photograph that was sent to me. I can't just continue to give the benefit of the doubt on every single thing that's occurred in this case. I just can't. And so I'll be turning that into the court. And I would just say, you know, at every turn of this, right, it's from the original case. It was, you know, I understand and very much respect the court's rulings on everything, frankly. You know, the grand jury,
sure you do.
You know, survived, you know, and there's no remedy. I get that. And, you know, they destroyed the gun and we have that hearing and there's no remedy.
They destroyed the gun.
It's just at a certain point, and the Brady just.
I did give you a remedy, but okay.
Well,
I didn't give you the remedy you wanted, but yes.
Fair enough. But so one might say not a remedy given all of the circumstances that has a meaningful impact at this trial. And so, and then we had the Brady disclosures, and I could keep going, and I'm not going to because we have limited time. But there's just never been any. It's just, I don't know how much of it can happen.
Mom, let's do this.
Carrie's being mean to me.
Okay. All right. I am aware of what you're saying, but look, first I have to see the picture. Okay. Now let's go to the arguments of this.
Yes, sir.
Okay. And then you can, you know, show me what you're talking about.
Anybody believe that Morrissey's
thank you.
signaling?
Your Honor, since we did submit the written briefing, I will try to be brief, but I think it'd be helpful to build out some of the facts so Your Honor has the chronology of how this happened and has the factual pieces to understand the severity of what's happened.
Okay.
So on November 1st, 2021, shortly after the Rust incident, Seth Kenny's on the...
Just one moment. I need Faith to get me my notebook.
Of course.
My notebook. I brought it up yesterday.
More conspiracy
might even be
theory.
in my computer bag.
The evil actor
Okay.
Seth Kenny.
Go ahead. I'll take notes on this.
Was Seth Kenny holding the gun that shot and killed Halyna
Yes.
Hutchins?
Thank you. So November 1st, 2021, Seth Kenny is on a phone call with Corporal Hancock. At that point, we've heard about Seth Kenny's involvement in this, his effort to pry into what's going on with the prop card and the bullets. And so on that phone call, he's telling Corporal Hancock, then Detective Hancock, that he believes he knows where the live bullet came from. He dials in a guy named Teskey, who we heard about yesterday in testimony. Teskey gets on the line and Seth says, tell Detective Hancock what you know. And he says, well, Fel Reed dropped off a batch of live ammunition at my business because I have a safer place to store it. And after that, Fel shows up, grabs some of the live ammunition and leaves some behind. And that's what I know. And Seth says, well, that could be from the same batch that killed Halyna Hutchins. Could be a match. He says, and it's Fel Reed and it's Hannah Gutierrez Reed. That's the one who's responsible here, pushing it off on Gutierrez Reed as the source of the live ammunition, just as the state has done in this case. He says, thank you very much. He gets off
Irrelevant.
the phone. Thel says, Teskey says, I'll take a picture. I'm not in front of my computer, not in front of my ammunition. I'll send it in an hour. He sends a picture of 4 bullets. Ms. Morrissey is going to hold that up to you and say, these are the 4 bullets you knew about this. That was from 2021. Detective Hancock does not preserve the other live ammunition that's at Teskey's property, even though he told her this could be from the live ammunition batch that matches
This
the
is
bullet
all
that
for
killed Halyna
cross-examination.
Hutchins. 2 years later, November 2nd, 2023, there's a PTI of Teskey. Ms. Morrissey's asking questions, and she starts probing further into the live ammunition that Teskey had previously said was given to him by Thel Reed. And she says, do you still have some of that ammunition? He says, well, some of it, but I've been out shooting it over the last 2 years because Detective Hancock did not preserve it over that time period. Ms. Morrissey probes further. Where'd it come from? Tell me your story. He says, well, Thel dropped it off. He then picked some up, and he went with Seth Kenney to the 1883 Yellowstone movie, where he was teaching people how to shoot with that live ammunition. He then went to another movie with Seth Kenney, teaching people how to shoot with that live ammunition. And Seth Kenney then took a green ammo can with that live ammunition in it and brought it home with him. He says that could be the live ammunition from that green ammo can that killed Halyna Hutchins. Ms. Morrissey says, I want you to preserve that. And do you think there's any evidence that this was sabotage? And he says, well, actually, Seth Kenney called me while Rust was shooting, telling me he wanted to get Hannah Gutierrez Reed fired, but he didn't know how to do it because he was concerned about upsetting Thel Reed, significant armor in the business, as Your Honor knows. And so he says, I don't have evidence that there was sabotage, but that's what I know, and I still have this ammunition. As we know, Sarah Zachary, the one who threw the live bullets away, we don't know, live or not, threw bullets away after the incident on Rust, admitted that.
None of this is evidence. Of what? This is all speculative
Was on
conspiracy
set.
theorizing.
Texting with Seth Kenney, angry with Hannah. On the license, the ATF report for the Pieta that was involved in this accident, she was on set. They were close, we know that. And so Ms. Morrissey says, you hold on to that evidence and I'll come get it, in essence. She never does. November 2023. Fast forward to March 6, 2024. The end of Hannah Gutierrez Reed's trial. Teskey's in Santa Fe. Sees what happens, shows up at the sheriff's office, as we heard from Ms. Popple, and delivers that live ammunition that Hancock had not preserved, that Ms. Morrissey had not collected, that he believed could be from the same batch, from that same green ammo can that we care about, that matched the bullet that killed Halyna Hutchins. We heard, Your Honor, what Ms. Popple did with it. They buried it. I'd like to say charitably that it was under the pile of the 5501 information that they didn't disclose, but that's even too charitable because they put it under a different case with a different number. We asked March 26th, we want all of the ammunition from the Rust set that you've collected. April 16th, we show up for that viewing. We want all the live ammunition from the Rust set that you collected. It's not there. After Teskey had turned it in, after Ms. Popple had created the report, the supplemental report she said she created when she took this in and did not disclose to us, it was not there. Now, Your Honor, we don't know if it's a live ammunition match or not. But what we do know is the state had it, it's disclosable under Giglio, it's disclosable under 5501. And there's a case on point, Your Honor, State versus Allison, where the criminal defendant had been charged with conspiracy, aggravated assault.
It's irrelevant where the bullet
dishonest
came
related
from.
crimes.
Irrelevant to this.
And he
case.
had an arrest record in the prosecution's possession. He had a statement and an arrest record. It was not disclosed under 5501. The criminal defendant shows up at trial and testifies. He's a great guy, honest, no criminal record. The prosecution whips out his arrest record and his statement, disclosable under 5501, which it never disclosed, and said not true. Court breaks. Defendant says, you didn't disclose that under 5501. And the prosecution says, who cares? He's up on the stand lying. This would not have been favorable to him at all. And so, Judge, I want a continuance. Give them a continuance. That's their remedy. Come back tomorrow. I'll disclose everything. I'll make it all right. And then we'll continue. Trial court says, fine, I'll give you that continuance. Limited remedy. You'll have all the information. Do with it what you will. If it's negative, fine. If it's not, that's for you to use at trial. He's convicted. It gets appealed. It ends up in the Supreme Court of New Mexico. That decision was reversed. The continuance is not adequate in those circumstances. They're in the middle of trial. The defendant would have done things differently. The defendant would have opened differently, would have asked questions differently. Too much about where the source, in this case, of the live bullet came in before this was presented at trial. The court said it doesn't matter if the defendant knew or should have known of it. What we're talking about here is not the defendant's knowledge, not whether it matches, not matches, not whether his criminal arrest record would have hurt him or not. We're talking about the conduct of the prosecution. And that's exactly what we're talking about here, Your Honor. We're talking about a prosecution that didn't preserve those bullets, that didn't collect them at all, that didn't turn them over, that we already have a 5501 culpability finding with respect to the last set of information. And Your Honor, the bottom line is we've got 5501 violation, culpability. We don't need to show bad faith. We've got a Brady violation. We've got a Giglio violation. Your Honor, this is critical evidence in the case that was never disclosed to us. We heard Ms. Morrissey say, I'm going to have Detective Hancock come in and testify. We could have Ms. Popple testify. They could say it doesn't match, et cetera, et cetera. It does not matter. It did not matter in Allison. We were entitled to it. The continuance is not a sufficient remedy. This case should be dismissed, Your Honor. This is over and over and over and over again.
No, you're complaining,
Your Honor, you've given
about
them
irrelevant matters
a
is
fair
over and over
chance.
and over again.
You said, grand jury, as Mr. Spiro said, I'm going to give you a remedy on Trumbetta. I'm going to limit it. I'm going to give you your remedy. You've given them more than enough opportunities, Your Honor. This is not the first time. It's not the second time. It's not even the third time. It's time for this case to be dismissed, Your Honor. That's what Brady requires. That's what Giglio requires. That's what 5501 requires. As Your Honor knows, we've got remedies in the alternative, but this is the one that's right for this moment. Thank you, Your Honor.
Thank you very much. Ms. Morrissey?
What the WTF? This is where she does well. Everything that guy said was bullshit. Where's the my cousin Vinny line?
Your Honor, there have been absolutely no violations of our obligations as prosecutors. I want to walk you through everything that has occurred in this regard, everything that these defense attorneys knew well before today, and everything that was also disclosed to Ms. Gutierrez's counsel. So what you can see from the transcript of Mr. Teskey's interview during the Gutierrez case prior to her trial is that Mr. Teskey is Thel Reed's close friend. And Mr. Teskey stores Mr. Reed's ammunition. And the reason that he stores it for Mr. Reed is because Mr. Reed lives in a single wide mobile home that doesn't have a lot of security. And because he's a professional armorer, he has a bunch of guns and ammunition. Mr. Teskey is a retired police officer who has a whole bunch of security at his property. So Thel Reed has 300 rounds of live 45 caliber ammunition. And he and Seth Kinney are hired by the producers for the show 1883. Everything that I want you to know, Your Honor, everything that I'm telling the court, Mr. Bowles has this information and these people have this information. So nothing I'm telling the court is new.
I guess Bowles is in court.
So
Carrie
they get
just
hired
gestured.
on this to do what's called a cowboy training on the set of 1883. So the cowboy training is where gun experts, that being Thel Reed and Seth Kinney, take the actors to shoot real guns with real ammunition so that they have a better idea of the recoil and how the gun is actually supposed to look, and to help them with their acting techniques. In fact, the fact that production companies do this was actually something that Baldwin pointed out to Detective Hancock during his interview. He himself has done this with a production company. So when they're through with the cowboy training camp in Texas, they've got some rounds left over. And Seth Kinney says, I'm going to take these. And Thel Reed lets him take them. So, and let me back up. When they originally went to the cowboy training camp in Texas, they didn't take all of Thel's ammunition. They took a certain amount of it, and Thel left some in Troy Teskey's garage. All of this ammunition came from the same place. This was all from basically the same batch of ammunition that Thel Reed had, that he got from a manufacturer, from an ammunition manufacturer in Kingman, Arizona, named Joe Swanson. So they take 300 of his rounds, they go do the cowboy training camp. Seth Kinney then takes the leftover rounds back to PDQ. So then what happens is Mr. Bowles begins to tell Detective Hancock, hey, you need to go execute a search warrant at PDQ because there's this green ammo can that Seth Kinney took after the 1883 training camp. Hancock, to her credit, takes Mr. Bowles at his word. She gets a search warrant. She goes to PDQ. What Mr. Bowles said would be there was there, and you've seen pictures of it. There's a green ammo can, says 1883 live ammunition. They take it, they send it to the FBI for testing. Not only does it not look like the live rounds from Rust, but it has a different chemical composition. So at that point in time, Hancock has kind of realized, I think, that she's being led down this path by Mr. Bowles that's coming from Thel Reed. Thel Reed is trying to slough everything off on Seth Kinney. So I want to show you when Seth Kinney is with Detective Hancock, what Mr. Nickus was referring to. He reaches out to Teskey because he's there with Hancock, and he says, hey, send me a photo of the live rounds that you have left over, because I'm giving her the live rounds from my green can. I think he just gave her some of them. They hadn't executed the search warrant at that point in time. Teskey says, okay. And he sends to Seth Kinney, you can see November 1st, he sends him that photograph of the live rounds that are in his possession. When you look at that photograph, and I'll blow it up for you, you can tell these are not similar to the live rounds that were found on the set of Rust. Detective Hancock gets this information from Mr. Kinney. Ultimately, though, still goes ahead and executes her search warrant as she should. I come into this case, I look at the ammunition that was taken from PDQ. I understand from the witnesses that the ammunition was sourced originally from Thel Reed. It was sourced from Hannah's dad. It's not a match. Not only is it not a match when you look at it, it's not a match when you send it to the FBI and you ask them to conduct chemical testing. So this is a wild goose chase. This has no evidentiary value whatsoever. This is simply a man trying to protect his daughter, and he's doing it by providing information that doesn't even match. He's trying to provide evidence that doesn't even match the evidence that was found at the scene. So then let's cut to November of 2023.
Judge is going to be so pissed.
We do a
and this is just
pretrial
waste of
interview
time.
of Mr. Teskey. Let me back up. Detective Hancock reached out when she got this photograph. She reached out to Mr. Teskey, and she'll testify to this. If you want her to testify under oath, I'm happy to have her do it. She reached out to Mr. Teskey and she said, hey, you know, because you appear to be cooperative, can you just package that stuff up and mail it to me? Because he's in Arizona. He's not here in New Mexico. And he never does. He never sends it to her. She doesn't pursue it because on its face, it's not the same ammunition. Let's cut to November 2023. We're doing the pretrial interview of Troy Teskey, where he talks about the ammunition and he talks about what he knows, what information he has about the relevance of this ammunition. What's also very important, and I can have under oath testimony to this fact also, this pretrial interview that was done over Zoom was, well, Mr. Bowles was there. So this was never kept from Gutierrez's lawyers. It was her lawyers that were bringing it to us. So there was no issue there. The jury was completely misled yesterday. So this pretrial interview that takes place in November of 2023 is uploaded to our discovery server. And when it's uploaded to the server, Mr. Baldwin hasn't been indicted yet. When he is ultimately indicted, everything that is on that server is taken and it's put on a hard drive, and it's sent, I believe, to Ms. Clark, who isn't here right now. And certainly Mr. James is happy to testify that it was uploaded to the server, that he downloaded it onto that hard drive, and he provided it to Mr. Baldwin's counsel. So the jury was misled again yesterday when Mr. Spiro indicated we had no idea about any of this. They've had it the entire time.
I don't want to hear about how the jury was misled. I just want to.
So when I have the pretrial interview with Troy Teskey, if the court wants to know the reason that we didn't actually get the ammunition from him is because I said, since he's out of state and we'd have to get another law enforcement agency basically to go pick it up and take it and send it to us, I said, have him send me a picture of it so that I can determine whether it has any evidentiary value and I can speak to my case agent about it. The photograph that was sent to me is the photograph in the middle. That is not the same ammunition. You can tell from looking at it. It has a different projectile shape. That's not the same projectile shape. That's not the same casing. This isn't a Starline brass casing. And it also has brass primers and not silver primers. So I decided, I agreed with Detective Hancock, this has no evidentiary value. We're not going to continue to go down this rabbit hole. I want the court to know that the photographs that I spoke to Detective Hancock about yesterday, where it does appear that Ms. Gutierrez has the live ammunition in her own hand that was taken a little more than a month after Ms. Hutchins died, those are on the right. So you can see the bottom photo, you can see the Starline brass casing, you can see the nickel primer, and then when you look up here, you can see the shape of the projectile It's a spot-on match for the live rounds. There is absolutely nothing about the ammunition that Troy Teske had that has any evidentiary value in the Gutierrez case. It has no evidentiary value in the Baldwin case. This feels like asking us to go to every sporting their 45 caliber ammunition and send it off for testing. We're not required to do that. It simply doesn't have any evidentiary value, and the defense was aware of it. If the court, let me check my notes real quick. And another thing that's really important about the transcript of Mr. Teske's pretrial interview is he does not say, this is the same ammunition that killed Halyna Hutchins. He says, that's what Seth Kenney told me. Well, we've interviewed Seth Kenney countless times, and he's testified before Your Honor, and that is not what he says. He does not support that. So Mr. Teske indicated during his pretrial interview that he had no personal knowledge of whether or not this ammunition had anything to do with what was happening on the set of Rust. That all came from Seth. We investigated Seth. We talked to Seth.
The judge is going to be so pissed.
The
Smirky
only
little
way
face Luke Nikas had.
that this has, on the best of days, for this to be relevant information for even Ms. Gutierrez, it's not at all relevant to Mr. Baldwin, but even for Ms. Gutierrez, it has to actually have some exculpatory value. And you can tell from the pictures on the right, it doesn't. It doesn't have any exculpatory value. And I want the court to keep in mind, Hannah Gutierrez, when she was working on the set of The Old Way in August, before she came to New Mexico to work on the set of Rust, she sent Seth Kenney a text message. And in that text message, she said, is it okay with you if I shoot live rounds out of the set guns? And Seth Kenney responded and said, no, don't do that. In fact, what he says is, it always ends in tears. It did this time. Hannah Gutierrez admits to law enforcement that she loaded the gun. She points out the box of dummy rounds that she was sourcing ammunition from. During her November interview, she holds up a picture of the exact same box and says, I got this from my dad. My dad wanted me to show you the boxes of dummy rounds that we use. And it was a spot-on match. She actually indicated that she got the box of dummy rounds from her own father. None of this is exculpatory at all. This is the exact same batch of ammunition that has already been sent to the FBI and tested, because it all came from the same place. There's no reason for us to do it again. Thank you.
Your Honor, I don't know at this moment if the court is intending to take evidence or not, so.
She didn't call anybody.
Okay.
I can, if the court.
It is your presentation. I'm not going to tell you what to do
Yeah,
on your
sure.
presentation.
I'll do it then. We'll take evidence. If my offer of proof isn't enough, I'm happy to put witnesses up.
I just wanted to say one thing to the court, which is just simply that Ms. Morrissey, in her presentation, didn't say one word. Not one word.
Isn't this properly for Mr.
Well, I don't even say that. Well, he was making a legal argument if we're going to do an evidentiary hearing, because there won't be multiple lawyers involved. But so I would just simply point out that there wasn't one word about what was actually turned in. I don't know if the court realizes that. That was all about stuff that happened that.
All right, this is, thank you. All right, go ahead, Mr. Nikas.
I'll be very brief, Your Honor. If this evidence wasn't as important as we say it is, they would have turned it over. The fact that they concealed it, the fact that they put it under a separate document number didn't disclose a supplemental report, didn't disclose the bullets, didn't bring them to the April 6th evidentiary viewing. If it was that irrelevant, it had no evidentiary value, it would have been there, Your Honor.
Nonsense.
Number one. Number two, Ms.
What
Morrissey does
nonsense.
not get to determine what has evidentiary value and what doesn't. 5501 says it's required to be disclosed, period, full stop. And in fact, in the Allison case, it was not exculpatory. It was inculpatory. It was the defendant's own arrest record and his own lies to the state. And yet the fact that it was required to be disclosed under 5501 and the fact that it was not meant, period, full stop. We're not going to have a mini trial about this in the middle of the trial. That's exactly what the Supreme Court reversed the lower court for doing, what Ms. Morris is asking you to do. It didn't matter. It was inculpatory, but the trial would have been conducted differently. And because it would have been conducted differently, and that's exactly the truth here, this goes to credibility. It goes to the government's bias, improper motivation, and incompetence. I'm taking those exact words from the motion in limine ruling that Your Honor made. That goes into evidence. It's relevant to Popple's credibility, to Hancock's credibility. It relates to every single thing we've planned in this entire case, Your Honor. And right in the middle of it, Ms. Morrissey doesn't tell you what was actually turned in. She shows you a picture from 2021, a subset of the rounds that were turned in by Teskey, a subset. He said he shot a bunch of rounds in those 2 years. The picture was only of 4. This is critical evidence, Your Honor. And whether Seth Kenney is right or wrong, or how we debate whether he was involved or not involved, that's completely irrelevant. Because what we know is we don't have those bullets, and they were required to be disclosed so we could put on the case that's fair. And that's exactly what Brady says, Your Honor. Brady says that the administration of justice requires fairness. That was the entire premise of the decision, fairness. And that's all we've wanted from the beginning, Your Honor. And you've given them chance after chance after chance, and there are no more chances, Your Honor. Brady says it, Giglio says it, 5501 requires it. Thank you.
All right, thank you. Before I, and we can take testimony later if you all want, but I'm going to require that the state, in fact, I'm going to order that the state by 11:30 this morning produce the supplemental report, the file itself and anything in it, and also the rounds.
May I
that-
respond
I'm
real
not
quick?
finished.
Okay.
And the rounds that Ms. Popple took from Mr. Teskey.
I want the court to understand that last night, the defense reached out to Ms. Popple and said, we want you to bring the rounds to court tomorrow. And she got their message, and then they reached out to her again and said, no, never mind. We don't want you to bring the rounds to
Thank you,
court
Ms.
tomorrow.
Morrissey.
I
Thank
got
you,
them.
Ms.
I
Morrissey.
have them.
I don't, okay, where are they?
They're here. I'll go get them.
All right. Well, actually, I want testimony from Ms. Popple on how she retrieved those. So I don't need the box, tell her. I need Popple.
Yeah, where the ammo came from is completely irrelevant to Baldwin's criminal culpability here. If we had absolute proof
I have tendered the supplemental report to the defense.
that Gutierrez
Please raise your right hand.
and Seth Kenney conspired
Swear
to get
affirm
that
under
round
penalty
into
of
the
law that
gun
the
with
testimony
David
you give in this
Halls.
case will be the truth, the
It doesn't
whole
change
truth,
what
and nothing
Baldwin
but the
did.
truth?
Yes.
All right, thank you. Have a seat. Talking to the microphone. I would like to read the report. May I see the report?
Yes.
Nobody compelled Alec Baldwin to point what he knew to be a real gun at Halyna Hutchins, cock the hammer, and pull the trigger without ensuring there was no live rounds in the gun. If this was some giant conspiracy, I mean, maybe Seth Kenny's guilty of involuntary manslaughter. Who knows? But it's got nothing to do with Baldwin's culpability in the killing of Hutchins.
Where is this box of evidence?
In the other room.
I'd like to see it.
Okay, you just said you don't need the box.
Martine, I need the box of evidence.
The defense is not going with Baldwin thought it was a blank. Baldwin had no idea what was in the gun. He never looked. He had no personal knowledge of what was in the gun. Right? Seth Kenny was a Russian agent. Maybe Seth Kenny has something to do with Ukraine. Baldwin chose to rely on other people's representations of what was in the gun. He's free to do that, but then if he kills someone recklessly, he's criminally liable.
Have you all inspected this?
No, we have not yet.
Well, how do we want to do it? I want to look at it. Well, do you want me to ask the questions first? I have some questions of this witness.
You can ask first.
Can I open this, Martine? Anywhere? Like not in the middle, I mean up at the top?
Oh, now the judge has blue gloves on.
Maybe you need gloves too. Do you have gloves? Can you get some additional? So anywhere, I can just cut into it. Okay.
There should be there's a separate
All right,
area.
I'm going to have you. This is unusual,
Yeah, no
but
kidding.
if you all don't mind, and if there's any objection, I'm going to have her step down, and when I ask her a question about which is which, she will put it out. Is that all right with everybody?
However you want to do it. Judge.
Okay,
Sure.
so I just need you to have some gloves. And we're going to go right there. And you all can.
This is crazy.
Too, so you don't have to, I don't want you asking questions yet, but I do. Can you move that thing? All right, please pull out the 3 Starline brass 45 Colt. You need to refer to, you have your.
The state is not alleging that Baldwin brought the gun on set. They're not alleging that Baldwin loaded the gun.
Pair of scissors. I got it.
Yeah, the defense doesn't have a case on the merits. And Morrissey makes a good point. Are they supposed to go to every sporting goods store in New Mexico and test their 45 ammo to make sure it didn't come from there?
Take your turn.
I think the judge is just looking to see if she can find an obvious reason to deny this motion to dismiss the case.
I don't think gloves are necessary.
Well, that's your opinion. Thank you.
Havoc.
Go to the 3-2 BHA 45 Colt with silver and color primer.
Yes, Judge.
One CBC 45 Colt with brass and color primer.
That would be this one.
They're looking at rounds that have nothing to do,
3
no evidential
BHA
connection to
45
this
Colt
case.
with brass and color primer.
These three.
And one Winchester 45 Colt. I don't know if we need the Winchester.
That one.
2 Winchester 45 Colt.
It's silver primer with brass primer, silver casing.
Okay, got that. Okay, 1 SIG 45 Colt. All right, and then 10 Starline brass 45 Colt.
Seems pretty well documented.
All right, so do we have the microphone close by? Can you pick this up? Are you picking it up? That's my question.
We've got one here.
All right, so point out to me, let me ask you this. Did Ziegler tested the rounds in the Hannah Gutierrez case, correct?
Yes.
He didn't test any further rounds after the Hannah Gutierrez case?
No.
Okay. In the Hannah Gutierrez case, can you point out what types he did test from here?
I'm uncertain what types he tested.
This is a witness testifying, Ms. Morrissey. Please stop.
We sent all of the,
All right, let me ask it a different way. Do you recognize any of these types of bullets to have been gathered on the Hannah Gutierrez, on the rust set?
the Starline brass with silver primer are similar to what was collected on set.
And everything that was collected on set went to Ziegler?
Yes.
All right, thank you. I don't have any further questions, but I'll certainly allow some. I don't know if you want to be there with her or what.
If she can take the witness chair. Let's exit. Good morning again. I'm just going to pass the witness up, because we're not fully set up, the copy of the spent shell casing that was recovered on the scene of rough. And you would agree with me, right, that it's the same as the bottom of the bullets that you just provided to the court?
Yes, it's Starline brass 45 Colt with a silver primer.
So when I asked you yesterday, didn't he turn in ammunition that matched the ammunition that killed Ms. Hutchins? It's true that he did, correct?
And I did not recall at that time.
I understand that that's your position, but that's what in fact happened. Would you agree?
I would not use the word match without there being an additional analysis.
Well, who got to decide whether there would be additional analysis?
That was not myself.
It wasn't the defense though, right? We didn't know about it.
I don't know what you were aware of.
Okay. Well, you know that we came to have an evidence viewing where we asked to see every single round that could be related to the Rust set, and this was hidden from us. You do know that.
This was not hidden.
This was not hidden?
This was under a case number. It was documented. I was instructed to document it under this case number.
Okay, so in this case that's under the Rust investigation case number, you would agree with me, there's hundreds of things that you inventoried, right?
Yes,
There are hundreds of police reports that all relate to the same case number, right?
yes.
The one thing that seems to have been put under a different case number is just this one discovery of the actual ammunition that matches the ammunition from the set of Rust.
This was put under a doc information of someone coming in claiming to have rounds that were not utilized in a case.
Okay, well, let's examine that for a second. When Seth Kenny comes into the precinct and he gives you ammunition, you vouchered it, right?
I was instructed to collect the ammunition from Seth Kenny.
Well, let me take a step back for a second, just to make something clear. Investigator Popple, you're following orders, right, when you're doing these things, correct?
Can you please stop referring to me as investigator because it's creating a misnomer?
Okay, well, how would you, I apologize.
I'm
not
a
doing
crime
that.
scene technician. I'm not an investigator.
Okay, I'm only doing that because it's shorter than crime scene technician.
CST works.
Perfect, okay. CST Popple. When you took the, you're effectively following orders when you're deciding whether to voucher this or voucher the Seth Kenny evidence, right?
You keep using the word voucher, and I'm not sure what context you're using it.
Yeah, I apologize for that word choice also. When you inventory and make a report, I think your testimony is you're doing it at the direction of supervisors. Is that fair?
Most of the time, yes.
Okay. So when Seth Kenny walks into the precinct and gives you ammunition and says it's from the Rust case, you all inventoried it, right?
Yes,
You took photos of it, right?
yes,
You put it under the Rust case number, right?
yes.
You turned it over to the defense, right?
According to my knowledge, yes.
Okay. Somebody else comes in to the precinct, okay? A man named Troy Teskey, right?
Yes.
Who was a former police officer, right?
I believe he stated that, yes.
Okay. And I assume you all have the diligence to be able to confirm that, right?
I do not know if it was confirmed or not.
Okay. And he comes in and he also tells you he has evidence, right?
He told us 3 years later after a trial that he had evidence that the defense wanted him to use that he no longer wanted to hold on to.
Okay, let's break that down for a second, right? Mr. Teskey isn't involved in your meetings with the prosecutors and Corporal Hancock's meetings with the prosecutors up until the trial, was he?
Not that I know of.
Okay, so doesn't it make sense that he would have seen the trial on television, been completely outraged at what he was watching, not trusted law enforcement, and then walked it into the precinct? Doesn't that make sense?
I do not know what would make sense to Mr. Teskey.
Okay, didn't he in fact tell you, I don't trust Miss Morrissey and the prosecutors?
He did not state that to me.
He didn't on your oath? You're sure about that?
I do not recall him stating that.
So he turns this round in, and you, when he turns it in, obviously recognize it as Starline brass, nickel primer, Colt 45, correct?
Yes.
Okay, so it's not as if he came in and just turned in a bunch of shells, right?
He did turn in a whole bunch of shells.
Okay, but he didn't just turn in shells, right?
He turned in multiple different 45 rounds.
I'll ask the question a third time. He didn't just turn in shells, did he?
He turned in multiple 45 rounds.
Including rounds that matched the round that struck Ms. Hutchins, right?
Again, I wouldn't use the word match without further analysis.
And the reason that we don't have further analysis is you all didn't send this to the FBI for further analysis, did you?
We did not.
Right? Because if you had, it would have potentially proven the fact that all along, this ammunition did come from Seth Kenney. Isn't that true?
What I was informed of by Mr. Teskey was that the ammunition originated from Joe Swanson.
And then went in the green ammo can to Seth Kenney.
I do not recall him speaking about a green ammo can.
Okay, well, let me ask you this. You know, the other thing that you're saying, I took you at first to be saying, well, it's just a bunch of ammunition, and now we've gotten to the point where it's actually the same type of ammunition. And then you've also stated in your testimony that it's like, well, there's just this guy, Troy Teskey, that just walks into the office like it's random. When really Mr. Teskey and his involvement in this case was very well known to law enforcement, correct?
I had never heard his name before.
Okay, but he came in and he said, I'm here to give evidence about the Rust case, right?
He stated that he had evidence the defense had wanted and he no longer wanted to hang on to it.
Well,
And he was the one using the word evidence.
okay. You said to him when you came down at the first floor of the precinct, you were called because you were the evidence, the person in charge of the evidence, the CST, right?
Yes.
Okay. And he said, thank goodness it's you. You're the perfect person to take this because you know all about the Rust case. And you said, I know all about the Rust case, right?
I don't recall that.
Do you deny that?
No.
Okay. And then he said to you, this ammunition was in Seth Kenney's possession. And you said Seth Kenney's law enforcement is well aware of Mr. Kenney, right?
I don't recall that.
There's no jury here, folks, so I'm not sure
you
why all
take
the
this
theatrics.
ammunition on March 6th, right?
Yes.
The standard operating procedure for the Santa Fe Police Department says you're supposed to make your report within 24 hours, right?
Correct.
Okay. So tell the court, did you make your report within 24 hours?
I'm fairly certain that our SOP is that evidence should be submitted within 24 hours. I'm not certain on when the reports are supposed to be submitted.
So do you want to take your answer back? that you
Yes,
gave
I
a
do.
minute ago?
I apologize. Yes.
Well, we can enter that SOP into evidence. In this case, many times that are done the same day that the incident occurs. Can you agree with that?
Yes.
Okay. How much longer after this revelation did you do your report?
I believe it was, I apologize. I can refer to my report to refresh my memory. Oh, I have a copy. I believe it was the following month that the report was made.
Yeah, it was approximately a month later, right?
Yes.
Okay. What happened during that month? CST problem.
To be fairly honest, I went out of town to visit my dying mother.
Okay. I'm sorry about that. I'm sorry to hear that. Were you out of town that entire month?
I don't believe it was the entire month, no.
Okay. Who was involved in the word choice in this report?
Myself.
You didn't have any input? Because this doesn't look like the same language you use in the other reports.
Well, on a normal basis, I don't have conversations with people involved in cases.
But there was also other officers there that were aware of this. Corporal Hancock was aware of this, correct?
She was notified about it, yes.
Okay, and so was your supervisor who was there with you, correct?
Yes.
So you're not telling me and this court that you had no input at all in the drafting of this document, are you?
It was reviewed by my supervisor. I don't believe any corrections were made to it or requested by him.
You know, it's just, there's a funny sentence in it. It says, it's a sentence I've never seen in a police report. You tell me if you've ever seen this in a police report in your entire career. says, it should be noted that this is not actual evidence from the death investigation collected by SFSO detectives.
You are not reading my section of the report. You are reading what was written by Lieutenant Brian Brandel.
I was going to say, it doesn't look like you're writing. So the lieutenant writes in, thank you for clarifying that. I just got this report, as you know, right? The lieutenant writes in, it should be noted that this is not actual evidence from the death investigation collected by SFSO detectives. Did I read that right?
I believe so, yes.
Okay. In your career, going back to when you were a CST in Florida, all the way through the present, have you ever seen such a sentence in a police report in your entire career?
Not that exact sentence, no.
Yeah, me neither. So you're, if you could just look at this report for a second and help clarify for me which parts of this you filled out versus the lieutenant.
The section that starts at the top with my name.
Well, let's just go page by page.
That would be page 5.
Some of this may be reputational repair foundation when he gets convicted.
After this occurred, did this cause you?
They hid evidence.
Did this cause you concern, CST Popple, that this was handled this way?
It did not.
And as I asked you yesterday, you actually said when you were meeting with Mr. Teskey, this is the ammunition that we've been looking for from the Rust set, didn't you?
I don't recall stating that.
But you're not denying that.
I'm not denying.
So I don't know whether the most critical evidence in this case is the gun that was sent off to be destroyed or the round that killed Ms. Hutchins. It probably is the round that killed Ms. Hutchins. Would you agree with that those are probably the two most important pieces of evidence in this entire case?
I'm sorry. Can you please restate your
Sure.
long question?
Sure. Would you agree with me that the two most critical items in this case from an evidentiary perspective were probably the firearm in question and the live ammunition that struck Ms. Hutchins, right?
I would say the firearm and the live ammunition from the set.
Okay. And so the firearm, which we've had hearings, discussions about, was ultimately broken beyond repair by law enforcement, right?
Destroyed, he
Was-
said earlier.
Broken by the FBI lab.
Okay. And the report that was issued by the experts for the prosecution about that firearm and whether or not it had been modified before was buried also by the prosecutors, correct?
I do not know about that report.
Okay, and then we can turn to this second most critical piece of evidence in this case. And this was also buried by law enforcement, correct?
No.
No, it wasn't. Okay. Were you in the precinct when the evidence viewing occurred with the defense? I think you said yesterday that your partner or your colleague dealt with the evidence viewing.
Yes, my colleague and Detective Hancock, I believe, were there.
But you didn't, nobody asked you to take this vouchered, sealed evidence out and show it to the defense, correct?
When the request was made, I believe they couldn't quite narrow down everything that they wanted to view. There was quite a bit.
Oh, so this was a narrowing down issue? The reason that this wasn't shown to the defense is a narrowing down issue?
No, I'm stating that they couldn't quite tell me in detail what they wanted to see.
The request from the defense of all ammunition was taken by law enforcement to not mean the ammunition that you recovered that matched the ammunition that struck Ms. Hutchins?
I don't believe we looked at all the ammunition that day.
Well, no, but the request was all ammunition. So I'm asking you, did law enforcement interpret that request to not include this critical evidence?
All of the items that were pulled for the case were under the Rust case number.
Which was a perfect plan.
You're asking me if there was a plan?
Well, I'm saying whether there was or there wasn't, it worked out pretty well, right?
I'm not sure what you're getting at. There was a request to view the evidence from Rust. That is the evidence that was pulled.
Well, your report says this is evidence from Rust, and then it just puts it under a different case number, and the lieutenant then writes that sentence in saying this isn't evidence from Rust, right?
My report states that Mr. Teskey believed that it was related to Rust, and then I listed the case number next to that.
Do you remember when we started my examination of you yesterday, how I sort of said to you, the way you know what evidence to find is by what people tell you? Do you remember that?
Yes.
And that when you're at a burglary and somebody says, oh, you better pick up that glove, you don't know that that person's telling the truth or not, but you pick up the glove, right?
Depending on the circumstances of the case, possibly.
And here, a retired member of law enforcement walks into the precinct who's known to law enforcement, who turns in the matching ammunition, who tells you it's involved in the case, where there's tons of corroboration, both by what he provides and the history that law enforcement knows about this man. And you put it under a different case number, right?
I'm sorry, what was your question in that long statement?
You put it under a different case number.
Yes, as I was instructed to do so.
Okay, so you need to finish up so that Ms. Morrissey can cross-examine.
Yeah, I'm trying to review this in real time. So I will pass the witness. In a moment, 1 second. Oh, and I asked you this yesterday, but I want to ask again, which is, you told Mr. Teskey that you would write up a report because of how important this was the very same day, didn't you?
I don't recall stating the very same day.
You don't deny that, though, do you?
I don't deny it, but I don't recall it.
Okay, nothing further. For the record, that was State's Exhibit 29 that showed the witness.
All right, are we going to admit the supplemental into evidence?
Please.
Well, somebody move it in. I started the conversation. but
Defend, is it a court exhibit or just mark as defense? It's just,
I think it's, well, since I started it, are you okay with court's exhibit?
that's fine with me. And I think it gets.
However you want to handle it.
All right, court's exhibit what?
Come on.
All right, thank you. And it is, any objection?
No,
Any-
certainly not.
Go ahead.
If I can just pause for a moment and just address the court. Here's what I'm intending to do. Obviously, this is a serious dispositive matter. A full record needs to be laid. I have Mr. Kinney on his way over. He'll be here any minute. We intend to take testimony from him. I also intend to take testimony from Mr. Bowles. Judge, I have to make a record though.
Well, just a minute.
Okay.
The issue is the disclosure,
I
okay?
understand.
All right, so,
That's why I want to call these people, is it goes to the heart of the disclosure. So all I'm asking the court for,
well, we don't have time for this. So what I'm going to do, for example, like with Hancock, I'm going to have her get up on the stand and continue testifying about the case. And then this portion, just like you did with Popple yesterday, we will ask. You can call, move Seth Kenny up. You can move Seth, but he's going to do all of his testimony if you're going to do that.
so But here's the only thing I'm trying to do, and I don't mean to be frustrating. The only thing I'm trying to do is make sure that if this court grants this motion to dismiss, that I have made a full record, and I am entitled to do that. So I am getting my witnesses over here so that I can make a full record on this issue.
Well, what's interesting to me, to be quite honest, is that yesterday, you didn't even want to do a written reply. You wanted to just give an oral response.
I never saw these. I've never seen these, and I never saw the report. I have absolutely never seen these until this morning.
All right.
I've never seen the report until
So
this
ask
morning.
questions of this witness, and then you can line up your witnesses and I'll see. But we're going to go with Hancock after this.
Ms. Popple, I just presented to the court that I've never seen these until this morning. Do you agree with that?
Yes,
You've never shown me these, or I've never come in to see them, is that right?
correct.
Have you ever provided me that doc report?
No, I have not.
Okay. So, do you know who Troy Teskey is?
No, I do not.
I think we took some testimony from you yesterday that he is the friend of Thel Reed.
I believe that was stated, but I did not know that information.
Okay, so let me ask it this way. If Troy Teskey, who provided this ammunition, is a friend of Hannah Gutierrez's dad, and if these bullets,
I'd ask the prosecutor not to be touching those with her bare hands.
they rolled around for 3 years, okay. If these bullets
Rounds.
match the ones that were on the set of Rust, is that evidence, additional evidence that Hannah Gutierrez provided the live ammunition to the set of Rust?
Yes,
And has she been convicted for that?
yes,
Is this evidence that Seth Kinney provided live ammunition to the set of Rust?
no,
So let me ask you, Ms. Popple, if you buried it, how did the defense attorneys know to cross-examine you on it yesterday?
I do not know.
Do you have any idea when the defense attorneys learned about this ammunition?
No, I do not.
Do you know who they learned it from?
No.
Those are some important inquiries. Those are all the questions I have for Ms. Popple, but we'd like to take additional testimony.
All right. I thought I had one more question.
Oh, and I'm sorry. Would it refresh your memory about whether or not you're supposed to write a report within 24 hours if you
I
looked at-
don't think that was in dispute. I think
All right.
right? Never mind. Okay, so you're off the witness stand. Do we want to leave these out or do we want to gather them up?
I think they need to be vouchered and kept, obviously.
Well, okay, so it'll be Courts Exhibit 12? Is that how you want to do it?
Yes, I think it should be a court exhibit since this is a hearing, yes.
Okay, Courts 12. And my only question is, do you want them back in do you plan to examine anybody with these?
They have to be at the courthouse so we can, yes.
Well, she divided them all up is my only point. So is she gonna keep coming back and dividing them up, or what are we gonna do?
I think yesterday there was some testimony that I think was frankly just misleading, that none of the,
No, this is my question.
Yes,
You all, okay. What do you want to do with that? Because if you're asking a witness, then we're gonna have to pile them out of there and somebody's gonna have to line them up and identify what's this, okay? So do you want them staying out like this, or do you want them in the bag? That's all, that's my question for the day.
I think they should remain vouchered, and they are open like any voucher would be at a trial, when and if a witness is questioned about them.
Okay, so here's my question. If I put them back in the bag, they're all gonna be commingled, and you may not recognize them, so you can cross-examine appropriately or examine appropriately, okay? You're lay people. You have knowledge. I don't need to go into it. That's my only question. Want it in the bag, or do you want it out?
So what I would ask is, let us quickly just photograph it, and then we'll ask CST Popple to put it back and capture it, but remain in.
That's new evidence.
That's what I would ask.
All right. Is that okay?
Absolutely. My question for the court is, are we going to complete this motion hearing?
No, we're not going to complete it yet. Okay, I'm going to.
And can you just give us an idea so that we can be prepared for how you intend to proceed with regard to the motion hearing?
I'm going to have Hancock come up. You're going to call Seth Kenny, and I don't know why we can't do Seth Kenny's testimony if he's coming. Did you call him as a witness?
Sure, he's being called as a
Okay,
witness.
well, you should be prepared to call him. So we're going to do both, and I'm going to hear both.
So we're gonna hear from these witnesses outside the presence of the jury and then in front of the jury?
Oh, you're right about that. Thank you.
That's my issue.
Thank you for pointing that out. Well, other than telling the jury to leave for the and come back at 3, which I'm not going to do to them, I'm going to continue the testimony, and he would. Well, you said actually. I'm thinking why can't the jury hear this? They heard Popple.
I'm sorry?
They heard Popple.
Oh, absolutely. No, I'm not making a comment on whether or not the defense gets to bring this in front of the jury. I'm making a commentary on the jury doesn't hear our motion hearing, and I just want to.
Oh, they're not going to hear.
hearing.
Okay. I'm going to take evidence from each of these folks. Do you have, is this a problem? So I don't know what I'm going to do yet, so this is why I want to do it this way, okay? I want Hancock on the stand. You can question her about this issue, okay? Seth Kenny comes, you're going to do all of his testimony, including this, okay? Bowles is separate. He wasn't going to be testifying, okay? And on Bowles' testimony, the jury will leave, okay? And anything further on this motion, the jury will leave. But I think that they can do Hancock and Kenny in front of the jury.
Can Mr. Spiro and I approach?
Sure.
This is so weird. So normally these kinds of motions, the jury would have zero involvement in hearing any of this. By the way, I agree with the defense that the bullet that killed Halyna Hutchins was buried. No question about that. It was buried by their client, Alec Baldwin, in the shoulder of Joel Souza, where it was recovered by surgeons. Yeah, the judge conflating this hearing with open court testimony is it's just weird. It's weird. Properly, she should be hearing testimony about this hearing separately, making a ruling separately, without the jury being brought in. But that'll waste hours and hours and hours. And meanwhile, the jury's been there half an hour already, just sitting on their hands, or whatever they're doing. And the judge, she wants this to be an 8-day trial. And the defense is doing everything they can to take the wheels off the normal procedure of a criminal trial. This bullet, none of this has anything to do with Alec Baldwin's culpability. His culpability is premised on the state claim, not that Baldwin was the source of the ammo, or brought the ammo on set, or loaded the ammo into the gun. The state's not claiming any of that. They're claiming Alec Baldwin had what he knew to be a real gun in his hand. He pointed it at Halyna Hutchins. None of this is premised on any state claim that Alec Baldwin was the source of the ammo, or brought it on the set, or loaded it into the gun. The state's theory of culpability is that Alec Baldwin had what he knew to be a real gun in his hand, pointed that gun directly at Halyna Hutchins, cocked the hammer, pulled the trigger without ensuring there was live ammo in the gun, and killed her. That's the reckless conduct. It's got nothing to do with where the bullet came from or how it got in the gun. Nothing in this Baldwin trial has anything to do with that. That the judge, I don't know why Morrissey's not raising relevancy objections to this whole line of argument. It's completely irrelevant. Just like it would have been irrelevant in the Hannah Gutierrez trial, that that Alec Baldwin was the person holding the gun. What difference does it make who was holding the gun in the Hannah Gutierrez trial? All that matters for Hannah Gutierrez's guilt is someone was handling that gun. It resulted in the death of Halyna Hutchins, and it was Hannah's responsibility not to allow live ammo into the gun. This is not a trial about the bullet. The defense wants you to think so. That's why they keep talking about it. They want the big question to be, just like their client Alec Baldwin said in the Stephanopoulos interview. The real question is, where'd the bullet come from? That's what we have to know, where the bullet came from. Well, that is a question of the broader investigation. And we've already held Hannah Gutierrez legally culpable for being the source of the bullet. And we've held David Halls legally culpable for not detecting the bullet before he announced the gun was cold and handed it to Alec Baldwin. And now it's time to hold Alec Baldwin legally culpable for his misconduct. The pointing of what he knew to be a real gun capable of firing real bullets at Halyna Hutchins unnecessarily, not just without justification. It was unnecessary. There was no need. There was no direction to do this. It was not a scene. Pointing the gun directly at Halyna Hutchins, cocking the hammer, and pressing the trigger. All of which could have been done safely if he'd acted with due caution and circumspection and made sure there was no live ammo in the gun. Again, Baldwin's daughter was to have a bit part in this movie. You'd think if Baldwin was going to be pointing what he knew to be a real gun at his daughter, cocking the hammer and pulling the trigger, he would have personally made sure there was no live ammo in that gun. You think if the scene had called for Alec Baldwin to put a gun to his head and cock the hammer and pull the trigger, he wouldn't have made damn sure personally there was no live ammo in that gun. That's the failure of due caution and circumspection here. Guns are inherently dangerous instruments. We all know this, especially Alec Baldwin, who's on the board of a gun control group that exists because guns are dangerous. But we all know, all civilized peoples know that guns are dangerous if they are not handled with due caution and circumspection, if they're handled negligently. That's why New Mexico has an independent criminal statute for negligent handling of a firearm. And if death results from that negligent handling of the firearm, it moves from a misdemeanor to a felony involuntary manslaughter. Let's see. Take a look at the Law Self-Defense member chat. By the way, good opportunity for me to mention, don't forget, this Sunday, we're doing an afternoon recap of the trial to date. And my good buddy, Adam Baldwin, not Alec Baldwin, Adam Baldwin will be there. Many decades on movie sets, TV sets, handling guns, lots of experience with that in Hollywood. He's going to share that experience with us. We'll tell a few jokes. And we're giving away $10,000 worth of prizes. You do need to be present to win one of the prizes. We're going to be pulling names from the people who are present. This will not be on social media, not on YouTube, not on X, not on Rumble, not even live stream to members. We're setting it up as a webinar so that I can say whatever I want and show whatever I want and not get in trouble with social media. It's free. It's 100% free, but you do need to register because it's a webinar and there's only 500 seats, folks. And I know they're going fast. So go to lawofselfdefense.com, trial recap to register. Free, but you have to register to get a seat. That'll bring you to this, and just click that blue button, get your free seat, but you do have to register.
I call in the jury. This is on the record again. After I call in the jury, I'm taking a bathroom break, and we're probably taking a break for a good 20 minutes or half an hour even. Okay? Just want to settle.
Why? Why are we bringing the jury? What? We're going to bring in the jury and then take a break?
Are you bringing him in right now?
Yes, he's calling them in.
Okay.
I don't understand why we would be doing this. This doesn't really... She's just going to apologize to the jury for having them wait for an hour and then dismiss them again for the morning break? see. For all we know, it was a person on the grassy knoll who killed Halyna Hutchins, who threw the ammo onto the set of Rust. The bench conference was just about the logistics of doing all this. So this motion hearing to dismiss should be argued outside the hearing of the jury. You bring the relevant witnesses in, they testify without the jury present. And then when it's time, you decide that, and assuming the judge decides not to dismiss, you get back to the trial proper. You bring the jury in, you bring the witnesses in, and they do the trial testimony. It should be separate. The judge is trying to save time by saying, well, I don't mind if the jury hears some of this, so we can have the hearing testimony in front of the jury too, at least some of the hearing testimony. And I think it just makes everything incredibly complicated. It serves the interest of time efficiency, but I think it at a great increase and risk of complexity and confusion. Everyone's up, jury coming in.
All right, you may be seated. We're on the record. Jury, thank you for coming in. I'm going to recess you for the day.
Oh,
Sorry.
the whole
Trials are
day.
fluid. It's not something we predicted. Okay. So if you all can return at 8:30 tomorrow morning. Monday. It's been a longer week than usual. Okay. So Monday. Okay. So have a great weekend. Please don't talk among yourselves or anyone else about the evidence received here in court. Don't read any accounts.
Oh, she must be
Don't
smoking
do any
mad.
research. Don't go on Google, et cetera, et cetera.
How do they finish
Okay?
by Friday now?
Thank you so much for your patience.
They just lost a
Appreciate it.
whole day to this. Man, if this trial runs into my British Columbia motorcycle trip, I'm going to be really pissed. I got a lot of hotel reservations lined up. Yellowstone Park is waiting for me.
Thank you. We're still on the record. Ms. Popple, gather this while we're on break.
We're just going to photograph it actually.
All right. Can she gather it on break?
Sure.
Well, she needs to stay in the courthouse or be close by. Okay, thank you. We are in recess.
Okay. So we are in recess for 20 or 30 minutes. Madness. This is all madness. And it's all completely irrelevant. I can't believe we're wasting this much time on all of this. This is crazy. Hey, folks, I've been talking about this with great excitement. And yesterday we checked, and this is our Sunday afternoon recap of the trial to date. We'll have clips from the highlights, like some of this stuff today, crazy. Clips of Kerry Morrissey destroying the defense on redirect of witnesses, several of those cases, maybe some of the histrionics from the defense. We'll spend time doing that. I'll give you my thoughts on where I think the trial is moving forward from here. We'll also have my good friend Adam Baldwin joining us, talking about his decades of experience on movie and TV sets handling real guns. So he'll be sharing that with us, telling a few jokes. We can do some Q&A with Adam. Adam, of course, from Full Metal Jacket, The Patriot, Independence Day, Firefly, Serenity, The Last Ship, Chuck, and much, much more. Been a friend of mine for a long time. He's agreed to come on the show and talk about this. No relation to Alec Baldwin. And we are giving away $10,000 of prizes. $10,000 of prizes, but you do have to be present. And I'm talking about this again now because I just got a text message. Last night we had like 50 seats left. And I just heard that we expanded the number of seats. So, but they are going fast, folks. So I would urge you, if you're interested in joining us for this recap, grab your seat now. lawofselfdefense.com/trial recap. Today's the last day to get them. I'm not streaming tomorrow about this trial. So today will be your last opportunity until court recesses for the day. I don't know if she's going to spend the whole day on this motion to dismiss. Grab your seat, lawofselfdefense.com/trial recap, or scan that QR code there, and you can, it'll open up the page you need. Again, it's 100% free. Doesn't cost anything. That'll bring you to this page here. Just click that blue button for your 100% free seat. But if you don't grab your seat, it'll be gone. First come, first served. That's how that works. If you're watching on YouTube, I would appreciate it if you could hit the thumbs up button. What do we got for thumbs ups? We have 1,400 people watching. What happened? I just lost the live stream from court. What the heck? That's curious. I didn't think the court was going to, I assume she's coming back to do this hearing. Law and crime, what are you doing? Is there still? What do we got? Here's Reuters again. All right, well, I got a different feed. Outside the courtroom now. Looks like homeless people. I'm not sure what's going on there. All right. Well, anyway, back to what's important, which is this. So again, last time, grab your seat. You'll want to do that. Also, I was talking about YouTube. We got 1,400 people watching. We have 400 thumbs ups now. So give it a thumbs up, folks. It's free. If you like this kind of content, you like our jokes, our humor, that's very kind of you. And you can subscribe and hit the bell. Subscribe and hit the bell. Let me copy this. Send that to myself. Managing everything here, Folks, Captain of my own ship here. Okay. Now, for questions and comments, I'll dive into those now. First, from the Law of Self-Defense members. Law of Self-Defense members get their questions and comments answered for free. If you're on YouTube and you want a question or comment answered, it needs to be a super chat, $10 minimum, $10, or 107 Norwegian kroner, apparently, 107.23 Norwegian kroner. We learned yesterday is $10 US. And on Rumble, it needs to be a Rumble ramp of equivalent value. But I don't encourage you to do that. Instead, become a Law of Self-Defense member. You can become a member for 99 cents, folks. Get all your questions and comments addressed for free. Oh, excuse me. Oh, that was awkward. Get all your questions and comments addressed for free for just 99 cents. That's a 2-week trial membership. Should get you through this trial for sure. After that, I need someone here to pat my back. After that, we will After the 2-week trial, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law Self-Defense member. And you can cancel anytime if you decide it's not for you. But at least try out the 2-week trial for lawofselfdefense.com/trial. You'll get emailed instructions for how to join us on the member live stream and the member Q&A, the member chat, which is what I'm looking at right now. Let's see. What's new? What's new? Law Self-Defense member Texas John says the defense is purposefully eating away at the state's time. It's a calculated tactic to keep the state from presenting more evidence. It's certainly a very disruptive presentation of evidence to the jury, isn't it? Perplexed why the judge is allowing this exploration from the start of the trial. Yep. So the defense is now a forensics document specialist. Konsaki member says the judge can just give more time to prosecution for the defense wasting time, but she doesn't want that to do that. And she doesn't want this to be a 4-week trial. Elman says, is this what New York lawyers do? And a reply in the comments is when they have a shit case. Yeah. And they have a shit case. Alex Spiro, by his bio, is an expert in investigative techniques. Word, he would have missed this then. Denver says it's not evidence of the death case for Baldwin charges. Correct. It's completely irrelevant. Denver says the defense promised the judge in pretrial hearings not to do this type of stuff. In fact, they said, Your Honor, it's not us, the defense, that's making everything drag out. That's not our fault. It's we could do our whole case in 2 days. And the judge said, all right, out of the 8 days of trial, you get 2 days. And they promised they wouldn't, because the judge was concerned about the defense doing things like burning time and cross-examination. The defense spent 3.5 hours on cross-examination of Marissa Popple, the crime scene tech, before we got to any of this stuff today. This is just from the first 2 days. 3.5 hours of cross-exam of Marissa Popple, crime scene tech. Crazy. What are they going to do when they get into important? What are they going to do when they cross-examine Hancock? 8 hours? 16 hours cross-examining Hancock? What about Seth Kenney? 4 days cross-examining Seth Kenney? Let's see. Cycle Boy asks, with a reckless death charge, if an actor throws another actor off a building into an airbag and prop stunts didn't properly fill the airbag and thrown actor dies, per law, is throwing actor criminally liable? Now, the difference is, the reason that's a bad analogy is that airbags don't routinely cause death and serious bodily injury. Real guns do. Airbags are not inherently dangerous instruments. Real guns are. Let's see. Baldwin pulling the trigger is the most critical piece of evidence. I actually don't think it is. I think Baldwin pointing the gun directly at Halyna Hutchins is the most critical piece of evidence. If the gun had gone off then for any reason, because the defense is saying the gun malfunctioned. Well, if that's a real possibility, the recklessness was then the pointing of the gun, which the safety rules also say you shouldn't do. Let's see. The normal function of a gun is to fire hot pieces of lead at high velocities. That's not the key purpose of an airbag. Let's see. Destroyed. Yeah, if this was a drinking game, destroyed would definitely be one of the words. Destroyed, accident. I guess I shouldn't say anymore. It's a drinking game, right? Given current events, but a bingo game, bingo card. Masters of Criminology. I don't see how Baldwin is liable if he truly believed the gun to be safe. He can't because it's not an informed belief. The only way to have an informed belief that the gun was safe would be to inspect the gun for live ammo. He didn't do that. He just took someone else's word for it, which he would not have done if he was pointing that gun at his child or at himself. It was a scene that did not require even dummies in the gun. It would have taken a moment to ensure that gun was completely safe, and he didn't do it. That's the lack of due caution and circumspection. When you're handling an inherently dangerous instrument, it's not enough to just say, well, I'll just assume that it's safe. Let's see. Evidence collected at the scene is not the same as quote unquote evidence that walks in the door without provenance or chain of custody years after the event. I mean, I think there's weight to that argument, but I wouldn't care if Teskey walked into that precinct with bullets that precisely matched the round that killed Hutchins. So what? What does that have to do with Baldwin's conduct? It doesn't matter. It's completely irrelevant. Yeah, it's not inconceivable that a gun on a movie set can kill people. They've killed people. And they're certainly capable of killing people. We all know this. Another good point in the comments with the airbag scenario. The person who's being thrown off the building onto the airbag volunteered for that job. They're assuming that risk. Halyna Hutchins did not consent to having a gun pointed at her. And even if she had, she did not consent to having a gun with a real bullet pointed at her. She certainly did not consent to having the gun pointed at her, the hammer cocked, and the trigger pulled. Wish Gosney was here. Gosney knows he's welcome. Let me see if there's any kind of... Yeah, I don't have any text messages from him. But Gosney, Steve Gosney, attorney from Florida, great guy, good friend of mine. He's welcome. Very, very experienced attorney, criminal attorney. Nick Riqueda's welcome anytime. Joe Neerman's welcome anytime. They all know that. I've spoken with all of them. Denver says, if I were the state, I would have tried to exclude this line of defense during pretrial motions. The entire line has no evidentiary value. Maybe they did, and there was an order pretrial that allowed the defense this line of argument. If there was, I don't remember hearing that. I am wondering why Morrissey's not objecting on relevance grounds to this whole line of argument. They may as well be arguing about what was the source of the lead of the bullet. Where did the lead come from? That's the important question here. Is it American sourced lead? Did the lead come from Canada? Could it be that Mexican lead? We all know that Mexican lead, right? You bring a piece of ceramic back from vacation in Mexico, it always says lead free on it. Written like in a Sharpie pen. No problemo, senor. Lead free. Sure. I can imagine the testing that was done to confirm that. Liam says it was the prosecution who started all this irrelevant stuff about the ammunition. No, the defense has been talking about the ammo forever. I mean, the state just knows that the defense is going to talk about it. So if you make the first opening statement as the prosecution, if you know the defense is going to talk about the ammo in their opening, you can't not talk about it in your opening. Let's see. Eric says, even if the buried bullets don't go to Baldwin's guilt, don't they raise an important evidential issue? No, it would have to be evidence relevant to a material fact in the case. How is the source of the bullet relevant to any material element of involuntary manslaughter? The charge against Baldwin. I mean, any object is relevant to something in the universe, right? That's not the question. In a criminal case, there's a criminal charge that the state has to prove beyond a reasonable doubt. There's elements of that charge. There's facts that are material to that charge. That's what matters, not the entire universe of questions. That's why we have courts and we have criminal procedure and we have rules of evidence to constrain the arguments and evidence that can be brought into court to those that are relevant to the legal issues involved. Let's see. I wonder who's Stephen. We got a new member in Stephen who seems to be a bit of apologist for Baldwin, which is fine. You're welcome, Stephen. Let's see. Now he writes, the reason Baldwin walked out of the trial yesterday is he has irritable Baldwin syndrome. Oh, I see now. I get the joke now. Thank you. IBS, irritable Baldwin syndrome. I've heard lots of, so I saw a little bit of the Twitter coverage of this trial, and I have to say there's a lot of bad legal takes out there. There's a lot of bad takes from what appear to be non-lawyers that are just emotional takes. They emotionally don't like Harry Morrissey. They wish the law was different. You know, they wish that the law of manslaughter applied different on a movie set than everywhere else. It doesn't. These are all just imaginary reasons why Baldwin would not be guilty. It's people are just uncomfortable with the legal reality, so they're waving their hands and saying, "This is not the manslaughter law you were looking for." It is. It is. A lot of the lawyers are having what I think are terrible takes, terrible legal takes. A lot of them are being gulled into this defense argument about where the bullet came from is important or how it got in the gun is important, not to this trial. Now, in fairness, some of those other lawyers talking about that other stuff, they may just be way smarter than me. I mean, not in terms of the law, but in terms of doing this social media thing. Many of them have multiples of like my number of subscribers on YouTube. I have 60 or 70,000. They have, hundreds of thousands, some of them. So they're way better at the social media game. And maybe that's what you need to do to be good at the social media game, is to talk about extra legal irrelevant stuff that the audience wants to talk about. Like, where did the bullet come from? Or is there a conspiracy between Seth Kenney and Corporal Hancock and whoever else they're throwing into this? Maybe that's what draws an audience. I don't know. But I don't know how to do that kind of stuff, folks. I just do the law here. So I just do the law. And maybe that's why I only have a fraction of our audience. Hey, but you can come to the trial recap. They're not doing that. They're not doing that. Come join me. Come join my buddy Adam Baldwin. We'll have some highlights from the trial to date, little video clips. I'll go over all the major issues again. And for those of you who haven't been able to watch every minute, and we'll give away $10,000 worth of prizes. But you must be present to win. It's 100% free. Go to lawofselfdefense.com/trial recap. It's not on social media. I want to emphasize that. You have to register because we're doing it as a webinar, so I can say whatever I want and show whatever I want, and not get pinged by social media. So we're doing it as a private webinar. So you have to register. It doesn't cost a penny. Go to lawofselfdefense.com/trial recap, and that'll bring you to this page. Just click that blue button, grab your seat. We did increase the number of seats because we were closing in on the 500 limit. So there's a few more seats available, but man, we got almost 2,000 people watching right now, and we're on a break. So as you can imagine, the seats are going pretty quick. Sunday afternoon, grab yours, lawofselfdefense.com/trial recap. I do have a stream of the courthouse running, folks, but it's just outside of the courthouse, the Herrera Judicial Complex. So, yeah, the defense is fecund, I guess would be the polite way to put it. The defense is very happy where they are now. They can see in their heads, they can see a they can see a dismissal possibility, which would obviously be an enormous win for them. I mean, they don't have the law, they don't have the facts. They're arguing over an irrelevant piece of evidence. And if they get this case dismissed on that, they deserve every penny that Alec Baldwin paid them. Every penny. Let's see. Kyle says, I'll just cheat on you with Emily Baker or Ian Runkle if you leave me hanging. I don't see much of Emily's stuff. She's got a huge audience, hugely successful on social media. I do know Runkle. I've never met Emily. I just know her from social media. I have met Ian Runkle in real life. He's a great guy. I'm sure he's doing great work on this trial. Let's see. Jeffrey says, judge to the defense. Everyone in the room is dumber for hearing this. I award you no points and may God have mercy on your soul. That is funny. Hey, YouTube, if you want, I'll turn to YouTube in a moment. It's got to be a super chat, $10 minimum. If you want me, I'm looking at the Law of Self-Defense member comments right now. Danny says, this morning's session demonstrates how unpredictable trials can be. Trials are not supposed to be unpredictable, folks. There goes a train. What's today, July 12th? I got about 2 weeks left in this office, folks. This office I rented a block away from a fire station and a railroad crossing where they blow the horn every time. And we have coal trains going by here like 12 times a day. 2 more weeks. Trials are not supposed to be unpredictable like this. They're not. In a perfect trial, it's completely scripted. Everybody knows exactly what witnesses will appear and exactly what those witnesses are going to say on direct and on cross. In a perfect trial, everybody knows exactly what legal arguments will be made and exactly what the jury instructions are going to be. The only people in the courtroom who should have any uncertainty, unpredictability about the proceedings should be the jury. To them, it's all new. But everybody else in a perfect trial, completely scripted, nothing unexpected or unpredictable happens. That's the goal. Because the purpose of a trial is not to develop evidence or develop arguments. It's to present evidence and present arguments to the jury. That's why these pretrial motions are so important, because they determine what evidence and arguments will be allowed to be presented. It's all supposed to be decided before trial. This stuff that's happening this morning in this case is not supposed to be happening on a trial. But when one side in the trial has so little legal merit, this is the kind of stuff they fall back on. Yeah, the judge doesn't seem so much in control of her courtroom right now. That's fair. Let's see. But it's up to Morrissey. This is part of being a prosecutor, especially in this case, a high-profile case like this, where the defendants got the money to bring in big guns. These guys are not dummies. I mean, their arguments are stupid, but they're making them because they're the arguments they have. Is 10 Canadian enough? Oh, you made it 20 Canadian. Thank you so much. Thank you so much. I can talk about my Canada trip in just a minute. I'll come back to your comment in just a moment. Let me pull up my my routing software so I can answer the question. I think I'll mostly be in British Columbia. I think I go through just a little tiny part of Alberta, but I'll double check. Let's see. Where's Banff? Is that right on the border? Banff? Is that how you pronounce it? National Park? I think that's right on the border, right? Between I'll pull up a chart in a minute, a map in a minute. I think there's let's see. What is that? What's the name of that town? Okay, I'll come back to it in just a minute. New Mexico has a special statute for guns being then you cut off. So it's it's a fairly standard legal principle that if you're handling something that's an inherently dangerous instrument and you commit an act of simple negligence that normally would only be good for civil liability, not criminal liability. But if you commit an act of simple negligence and you're handling an inherently dangerous instrument, it automatically gets bumped up to recklessness, the mental state, from mere negligence, civil only, to recklessness, sufficient for criminal liability. Sometimes when you have this transition, when negligence gets bumped up because of the inherently dangerous instrument, instead of calling it recklessness, they call it criminal negligence. All that really means is recklessness. New Mexico has a statute for criminal negligent handling of a firearm. It's a misdemeanor. But what that statute is doing, in effect, is bumping up the mental state of negligence to recklessness to a misdemeanor level because you're handling a gun while you're doing it. You're mishandling a gun while you're doing it. And then if you kill somebody as a result, that otherwise misdemeanor negligent handling of a firearm becomes felony involuntary manslaughter. Now those legal principles I just described that are statutory in New Mexico are not statutory everywhere, but it would not be uncommon to treat mere negligence in the context of an inherently dangerous instrument as recklessness for criminal law purposes. Kinsaki says the bullet's just a red herring. The only facts that matter: Baldwin held a gun, a real gun. He knew it to be a real gun, didn't check it, pointed it at a woman, and now she's dead. Yes, I concur. And because it's so simple, that's why the defense has to make it so complicated. Is the judge back? Let me take a look. Okay. Let's see what's live. Long crime. All right. Law and Crime is just streaming a talking head. Court TV. It says court is on break. You lying to me in the comments? I don't know that we'll have a PM show. It depends on the court. It's not quite 11 o'clock local time in New Mexico. Eric asked, per the airbag analogy, are you saying that if Hutchins consented to have the gun pointed at her, Baldwin would be off the hook? I thought you said you can't excuse reckless behavior. No, you can't excuse reckless behavior. So, remember, Baldwin did a combination of things, right? The gun safety rules are redundant. You have to violate more than one to have a bad outcome. He violated all of them. It's the combination of his conduct that constitutes the recklessness. Kyle asked, did I hear you say when they finished the film in Montana, there was no functioning weapons at all? That's my understanding. When they finished the filming of Rust up in Montana, one of the conditions of the crew union was, one, there was a special safety consultant that had authority that Alec Baldwin could not override, although apparently he tried to do that. The judge excluded that evidence from Montana from this trial, and that there would be no actual functioning real firearms on the set. It all had to be non-firing replicas of some sort. Now, I wasn't there, so I have no personal knowledge. I'm repeating what I think I heard that from Kyle Morrissey. Kyle. Sorry, Miss Morrissey. Carrie Morrissey. Eric says, the defense says the buried bullet goes to the prosecution's police competency and the quality of the investigation. They said if the evidence had been disclosed to them, they would have argued different. Well, they're always going to say they would have argued differently. I mean, look at the arguments they're making now. right? They're not making legally sound arguments. So if you're making inane arguments, you would have made different inane arguments if you had different evidence, I guess. But are any of the arguments relevant to the material facts of the criminal charge? They're just not. Let's see. Yeah, I mean, so Cycle Boy asks, Andrew, how would you defend Baldwin here? And unfortunately, Baldwin took the real defenses off the table the same day he shot Hutchins in his police interview. The best defense he could have had would have been when he talks to police, first thing he says is, listen, I had no idea that was a functional firearm in my hand. I believed, and he would need good reason to believe that this was an inoperable prop. For example, maybe it was the set in Montana, right? Where there was an established rule. No actual firearms on the set. Every gun we'll be handling is a non-firing replica. Every single one. Well, if you don't know it's a real gun in your hand, then you don't know you're creating a risk of death, an unjustified risk of death when you point it at another person. I would argue that's an absence of recklessness. You would need good reason to know that, but on the Montana set, you could argue he had good reason to know that. I mean, you have to believe it's a gun to believe it could fire. That's the problem here. He knew it was a real gun, and he told investigators that day he knew it was a real gun. Well, if you know it's a real gun, you know it's capable of firing real bullets. That's the problem for Baldwin. That's the heart of the unjustified risk of death to another, that he knew it was a real gun capable of firing real bullets. So how do you defend him? I mean, maybe you have to take the tactic his defense is here. If you can't talk about the merits of the case, you talk about other stuff to try to create confusion, create uncertainty, create something that looks like reasonable doubt for the jury. And then it's the prosecution's job, and to some extent the judge's job, to keep the jury focused on what's actually legally relevant in the case. Yeah, whether something should be legal, is a crime or not, is not determined by whether we like it or not, or whether we think that's the way the law should be. It's determined by what the law actually is. Yeah, I've got a live feed from the court here. Nothing's happening, folks. Eric is funny here in the member comments. He says the bullets are relevant to the state's investigation. If they tried to find the source of the bullets and they came to the wrong conclusion as to the source, it means they were incompetent and the investigation could be wrong in other ways, such as testing the gun. Well, they didn't test the gun. The FBI tested the gun. And there's lots of evidence about the gun's functioning. And you're allowed to impeach the state's evidence on the gun's functioning, which I'm sure the defense will do. But just because the state is incompetent, arguably incompetent in some irrelevant way, doesn't make their incompetency relevant to this trial. They would have to be incompetent in some way that matters here. Say one of the detectives has a terrible driving record. He gets in the car accidents all the time. He's been legally adjudicated an incompetent driver. And he sometimes drives patrol vehicles. He was driving a patrol vehicle during his investigation of this case. A known adjudicated incompetent driver. And he was driving a patrol car while investigating this case. Is that relevant to the criminal charge? Of course not, because his driving has nothing to do with the criminal charge. Oh, now we're back in the courtroom. All right. Let's see what's happening. Whoops. My volume's up. Here we go. It's just like if Baldwin had been reckless in some irrelevant way. Like, say Baldwin was a reckless driver. That doesn't have anything to do with the criminal charge here. That should not be admissible evidence. He's incompetent in some way other than his own. I don't know. Using spouses. Who knows? Grumpy judge. Grumpy judge. Someone needs to do like a grumpy cat meme. Here he is. He doesn't look good, man.
All right.
10:52 local time.
Call another witness. We're in the motion hearing.
In the motion hearing, Carrie Morrissey calls Hancock. Corporal Alexandria Hooters Hancock.
I can do it after Detective Hancock.
What?
We may approach very quickly.
Yes.
I got to bump the volume. Something's wrong here. I think it's the Court TV feed that's terrible. I did like the Reuters feed. I wonder if I can get that back. AP. They seem to have better audio. Oh, it keeps sending me to their Facebook page. Here, let's see here. No, that's not live. That's old. Well, we'll have to work with this, folks. But I did bump the volume by 100% to 200%. So we'll have to see. Yeah, our recap is this Sunday. Don't forget, grab your seat now. Grab it now before all the seats are gone. Am I the only guy that remembers the old race days when we had the little local racetracks? We used to have them even on Long Island, New York, and the radio stations when you're driving around. They'd say, Sunday, 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 come to the races. Well, this Sunday, you can come to the Law Self-Defense Trial Recap. We'll have my buddy Adam Baldwin there for part of that and talk about his experience handling guns on dozens and dozens of movie and TV sets over many, many years. But there are a limited number of seats available. We did add a few more this morning, I've been told, but there are a limited number available. Grab yours if you want to join us on Sunday. Also, $10,000 worth of prizes we're giving away, but you have to be present. You have to be present to win a prize. We're going to be calling names from those present, and you'll have to respond in the chat right away, or we're just going to call another name and give it to somebody else. $10,000 worth of prizes, including a real banger. I'll leave it at that. That's all Sunday, 2 p.m. Pacific time, 5 p.m. Eastern time. It's not on social media, so don't look for me on YouTube or X or Rumble or even as a member live stream, because I want to be able to say anything I want, show anything I want, and not get pinged by social media. So we're doing it as a webinar that we're hosting. So you have to sign up. Doesn't cost a penny, 100% free, but because we're doing it as a webinar, you have to sign up. So you go to lawofselfdefense.com/trial recap, 100% free. Click that blue button, grab your seat, and I'll see you all on Sunday. But once the seats are gone, they're gone, folks. So plan on joining us. You'll get an email confirmation with your login information and all that. We'll have plenty of time for Q&A, by the way. So I'll see if I can talk Adam into taking questions about, who knows, shooting, fireflies, life. He's just a great guy, Adam. I think you'll really enjoy your virtual time with him. I'll see him next month. September. I'll be down in LA and we're going to meet up again. Okay, well, I'm just looking at Carrie Morrissey talking to the judge with Alex Spiro. Oh, the court reporter. The court reporter buttoned up her shirt today. Huh. There was a little décolletage yesterday. Court clerk on the right there. It's got the dirty bun going. Judge is talking. They're trying to get their guidelines set. Somebody in the member chat, Kyle, says Runkle's recap yesterday was entertaining. Ian Runkle does great work. Runkle on the Bailey, maybe his handle on YouTube. He does great work, so I encourage you to take a look at his coverage of this too. I don't know if he's live streaming or just doing recaps at the end of the day. I'm not sure. Runkle does great work. And he's great fun in person too. Him and I have been at a number of the donut operator machine gun shoots down in Texas. Let's see. Jim says one's 100% responsible for what happens with a firearm. It starts the instant you take it in your hands and only ends when you pass it off to a responsible adult. That is correct. Will says it's that nefarious Chinese lead. If only I could do voices, I would do a Trump voice. That terrible lead. It's awful. It's terrible. American lead. Fantastic lead. Can't get enough of that American lead. But that Chinese lead, no good. Tariffs. They extracted it from foreign sidewalk chalk. Yeah, and Morrissey spoke to this, was the question of what's actually relevant here when she did redirect of Popple yesterday. Baldwin's not being charged with the crime of, sourcing the bullet or bringing bullets onto a movie set or putting bullets into a gun or failing to detect bullets. I've got to change my recording here. None of that is why we're here today. None of that is why we're here today. Boy, I'm going to have to take a restroom break. All right. I'll be right back. Did I miss anything? It doesn't look like it. Yeah, they called the that's why she called the jury back in. I was wondering. And she called them back in so she could release him for the day. The best defense here would have been the plea bargain. Morrissey offered Baldwin the same plea bargain. I'm glad someone mentioned that. The same plea bargain that David Hall's got. Misdemeanor, negligent handling of a firearm. Sentence probably would have been home arrest for 6 months, some community service, maybe a fine. She offered that plea to everybody. David Halls, Hannah Gutierrez, and Alec Baldwin. David Halls took the plea. Did, I think, 6 months home arrest, something like that. Misdemeanor. Hannah Gutierrez was offered that plea and chose to go to trial. Alec Baldwin was offered the plea, and while the plea was outstanding, he decided to go on TV and disavow any legal responsibility here. Well, a plea is an acceptance of legal responsibility. And so when he went on TV, George Stephanopoulos, and he disavowed legal responsibility, they took the plea off the table. So I don't know if he knew he was losing the plea when he gave that interview with George Stephanopoulos, but he was, and he did. I thought I heard a little volume there. Yeah, okay, we should be coming back. Let's see. Our trial recap Sunday. Still not back. Sunday, folks. 2 p.m. Pacific time, 5 p.m. Eastern time. You have to register. It's not on social media. It's a webinar. You have to have a seat, and I'm doing it that way so I can say whatever I want, show whatever I want, and not have to worry about the sensitivities of social media. But you do have to have a seat. 100% free. Go to law. My buddy Adam Baldwin will be there. Go to lawselfdefense.com/trial recap. Click that big blue button. Grab your free seat. Once the seats are gone, they're gone, folks. So that's where we are. The judge has her grumpy face on. No surprise there. We're giving away $10,000 worth of prizes at our trial recap on Sunday. But you have to be present to win, folks. So get that seat. lawofselfdefense.com/trial recap. Let's see. In an early interview, Baldwin claimed that Hutchins told them to point a gun towards her. If true, note that she did not consent to having a loaded gun pointed at her. That's right. And the SAG guidelines do allow for the pointing of a gun, right? Here they are. If absolutely necessary, the second sentence there at the top, if it is absolutely necessary to point a firearm at someone on camera, consult the property master or other safety representative. And why do you have to do that? Why that additional condition? So we can make damn sure there's no live ammo in the gun. That's why. And it was not necessary here, and it was not on camera. Notice on camera is underlined. This shooting did not occur on camera. This was not a filming scene. So that allowance for pointing of a gun to another under SAG guidelines does not apply on the facts of this. Now the police are coming by. In high crime Castle Rock, Colorado. I don't know. Can you guys hear those sirens? I'd like to think they don't go over the microphone, but oh my God, such a waste of time this is. One of the members asked, what happens if two people have the same username in the event? I think we're going to do it by email because we'll have your email because you registered for the event. But we'll work it out one way or the other. How many generations was it between Sunday, and let's get ready to rumble? I don't know. Probably a couple. Everything feels like it was 12 years ago to me. Like, when was the Hunt for Red October? My wife and I were talking about it because Alec Baldwin starred in that. I was like, was that 30 years ago? And she says, I think it was more like 40. Because she's quite a bit younger than me. 1990, 30, so 34 years ago. Quite a while. And Baldwin was good in that. He was good in that. I generally like Alec Baldwin in movies. He was great in Glengarry Glen Ross. I guess, see, one of the reasons I want to do this as a webinar is I can show some of those little movie clips and not get a copyright strike. He was great in that. He gave a great speech. I really liked him in that. He was very entertaining in 30 Rock, the TV show. He's very funny in the Boss Baby movies. I've got young kids. I've had to see that movie. I've got no particular critique of him as an actor in the stuff I've seen anyway. I can't claim to be some kind of super fan. But I don't care about any of that. One of the comments I see all the time when I interact with people on Twitter and I explain the legal realities, they're like, well, maybe so, but I'm not looking at this from just a legal perspective. Well, I am. I'm a lawyer. This is what I do. I just do the legal stuff. Beetlejuice. I forgot he was in Beetlejuice. That was a very funny movie. Yeah, I really like Beetlejuice. Beetlejuice, Beetlejuice, Beetlejuice. Of course, the other guy stole the film. What was his name? He was Batman, Mr. Mom. Michael Keaton. So when they list the stars for that movie, what am I looking at? IMDb. They list Alec Baldwin, Gina Davis, and Michael Keaton. Michael Keaton stole that movie. I mean, do you really remember anybody else from that movie but Michael Keaton? I can barely remember Alec Baldwin was in it. Very fun movie. Maybe I'll have to. I don't think my youngest kids have seen Beetlejuice. My Trump voice sounds like Nixon. I can't do voices, folks. Nick Rekieta does a good Trump, but he's not here. Let's see. I have a feeling that racetracks used to be more common than they are now. We used to have them even on Long Island, New York. I know we had some local ones. I don't know if they're still around. Let's see. Oh, that looks like I caught up on all the member questions. Let me take a look at super chats. There was one for sure I wanted to follow up on, the Canada $20 one. I can't remember now if I ended up addressing it or not. The motorcycle trip. I am going to Canmore, Banff National Park. Where is that? That's in Alberta, but it's on the very western edge of Alberta. And I'm just going to go to the eastern edge of the park, which is where Canmore is. I'm spending one night there, and then I'm coming back into British Columbia. But yeah, there is one night I'll be in Alberta. I was hoping to get to Edmonton, which is because I have some friends there, but I'm not going to be able to make it that far east, unfortunately. I have limited time. I'm going all the way to Vancouver and taking a very roundabout way of getting there. Let's see, someone's in the comments. Someone's messaging me on Twitter. Someone's using the car repair shop example. You take your car to the repair shop, they tell you it's safe, and then it fails and you hurt someone. The difference is a car is not an inherently dangerous instrument. Cars don't normally kill people, not readily capable in the normal use of the weapon. When you point a gun at someone, you cock the hammer, you press the trigger. It's your responsibility to make sure a live bullet doesn't come out and kill somebody. When you're driving down the street, it's just not the same dynamic. Especially, by the way, if you take the car and you drive recklessly, right? If you're speeding at high speed with the car, well, then you're responsible for your recklessness. If one of the causes of your crash is also that the mechanic did a bad job repairing your brakes, they may also share culpability for the harm that results. If I'm trying to think of a way that this could have, say Hannah Gutierrez had modified the gun, right? Had altered the trigger mechanism in such a way that if you bring the gun up to a horizontal position, the gun would discharge. I don't know how you would do that, but let's pretend that was possible. Normally, merely bringing a gun up to a horizontal position does not make the gun discharge, but it does that. This gun does that because Hannah Gutierrez modified something. That, I would say, is unforeseeable by Alec Baldwin. And therefore, the gun literally going off by itself because he raised it to a horizontal position, I would say there's no recklessness there. Unless, of course, he's raising it to point it directly at Halyna Hutchins. Or if the bullet had weirdly, ricocheted off some object, unforeseeable object. I mean, so you're holding it in a safe direction. I can imagine scenarios in which Baldwin arguably would not have criminally reckless culpability here. But he did everything wrong. He did everything wrong. He knew it was a real gun. He knew he was pointing it at Halyna Hutchins. He knew he was cocking the hammer. And the only evidence he didn't pull the trigger is his self-serving statement. We have eyewitnesses saying they had the finger on the trigger. We have this kind of photograph repeatedly of him putting his finger on the trigger when it wasn't necessary. So whether or not you believe he never touched the trigger, I guess is going to be a fact question for the jury. I don't think it really matters. I think the pointing of the gun enough by itself, especially the cocking of the hammer, is enough. You're putting the gun in firing mode. You're creating the risk of unjustified death or serious bodily injury, unless you've personally ensured there's no live ammo in the gun, which obviously he didn't do. Let's see. Denver says, FYI, TN just lost in court and they can no longer use the open fields doctrine to intrude into private property. I'm not familiar with that stuff, Denver. If you have a link to something, this is in the member chat. I'll be glad. I mean, I'll take a look at it after this trial's over, but I'll make a note to follow up. Nothing's happening in court, right? God, the judge must be so. Is the defense? It looks like they're flipping through papers. I guess were they just they're pretending they just got a report for the first time. I'll pull that back up. There's really nothing going on. Yeah, instead of Sunday, it's Beetlejuice. Let's see. Yeah, I guess I would have, a bigger social media audience if I pretended the legal issues here were not this simple, not this straightforward. I see other lawyers talking about this other stuff, like, well, where did the bullet come from? What if there was a conspiracy? Bum, bum, bum. I just can't bring myself to do it. All you get here is straight up legal analysis, folks, and the occasional dad joke. Let's see. I'm sure the jury's happy to get, although the jury may be thinking it's like a snow day, right? You get it now, but you pay for it later. And they wouldn't be wrong to be concerned about that. All right. So let's see. Back to the super chats. Yes. So the question from Canada. Banff is where I'm going. Am I going to Jasper? Am I going near Jasper? I'm going to Canmore. Where is Jasper? I'm going to Valemount. Valemount is in British Columbia, just west of the Canmore border. He says he's well, email me, Canada, Lost in Law. Email me at support@Law Self-Defense. Tell our staff will get it. Tell them to forward it on to me, and we can connect offline. I will. When am I going to be in Canmore? I will be there around. Well, you say until mid-August. I'm going to be there mid-August. So I don't know. Maybe we'll miss each other by a day. I'm not sure, but email support@lawselfdefense.com. Tell them to forward it on to me. Yeah, I don't think Jasper's 3 hours north of Banff. I am going north of Banff, but oh yeah, I'll be up by Jasper too. Yeah, I'm going through Jasper. I am going through Jasper as well because I'm going up. What is that? 93. So yeah, I'm riding up through northwest through Banff into Jasper National Park. Up to what's that town there? by Valemont. And then I start heading south back to into Vancouver from there. Yeah, it should be. I'm looking forward to it. It should be a fun ride. I've not ridden British Columbia before, so this is a bucket list ride for me, and a good opportunity to do it before I exit. Oh, there's a link. All right, I got the link about the Tennessee Open Fields case, so I'll make a note to check on that. Thank you, Denver. And I'm moving to Tennessee. I'm pretty sure. I'm 99% sure I'm moving to Tennessee. I'm definitely moving out of Colorado. This is it's almost impossible to being here on the ground in Colorado. You probably don't hear about it in the national media if you're not here. The velocity at which Colorado is becoming LA is especially Denver is unbelievable. Unbelievable. I've been here 8 years, I think. And 8 years ago, you could just take your family, kids, walk around Denver, and it was fine. Now this is how bad it is. In the tourist areas, like around the ballpark, okay, the tourist areas of Denver, the police are setting up rideshare meetup points with armed police where users of rideshares can aggregate under police protection because you can't even get an Uber in Denver safely. People are apparently standing outside of restaurants waiting for their Uber to come pick them up and getting robbed right there. Crazy. Cycle Boy says, I have to go in for jury duty this Monday myself. Everyone says get out of it, but listening to Branca, I personally wouldn't want to be stuck with the jury if people too stupid to get out of jury duty. So I think I'll just roll the dice. The good news is most people selected for jury duty, it's 1 day, 2 days, 3 days. I'd say 95% of juries are very short. I mean, and a lot of times you don't get picked for a jury at all. You show up to court, you sit there for a day or two, and then you usually just in 1 day, and then they dismiss you. Denver says, moving to Tennessee, you will lose the current outdoor sound effects, but you will gain freedom. I'll miss the geography of the Rocky Mountains here. They're gorgeous. Best riding in the world that I've ever done. I've ridden large parts of the world on a motorcycle, but I'll come and visit. I may leave a motorcycle back here and just come, for a week or two a year to ride around. Jason says, watch out for the bears in Canmore. My buddy coworker lives there. We regularly see moose and bear in the background of Zoom calls. I had a bear running up the sidewalk a block from my house in Castle Rock. I was riding home at night, and I kind of, out of the corner of my eye, I detected some motion, and I looked over, and there was a bear running alongside me, a little black bear running alongside me on the sidewalk as I was motorcycling up the street. Oh, he's I guess Alex being told the joke. He's whispering with hilarious. Carrie Morrissey stepped away. Everyone is standing up. They're breaking? It would be nice to know what's going on. All right, now I got a dead screen, the seal, the court seal. I will watch out for the bears, I promise. Shock Mike, super chat, $10. Thank you very much, Shock Mike says, my dad seems to think if the gun went off by itself, that would make a difference in Baldwin's guilt. Is he wrong? I don't think so. I think the pointing of the gun is enough. If you point a loaded gun at another person, you assume the risk of the gun discharging. That's why we have rules about don't point a gun at anything you're not willing to destroy. It's an independent safety rule. It's an independent safety rule for SAG. Anything at which you point a firearm could be destroyed. So you assume the risk when you're pointing your gun at stuff, especially if you're pointing it at a human. But in any case, there's zero evidence here other than Baldwin's self-serving statement that's contrary to every other bit of evidence in this case. There's zero evidence here that this gun went off by itself. Guns generally don't, and there's no reason to believe this gun was defective in a manner that would have would have made it go off by itself. Let's see. Liam says speed limits around Banff can be pretty low. Yeah, I'm tentatively planning not to do any speeding in Canada. So the Great Republic of Texas is off the table, probably is off the table as a destination for a move out of Colorado. It's a combination of, I have more people I know around Nashville, and the weather's a little more moderate, let's face it, and closer to family. And we found some schools we really like in the Nashville suburbs area. So it looks like Nashville. And I don't really, I mean, I have no family anywhere near Texas. No family I like anywhere near Texas. Let's see. Kansaki asked, but how will the Denver Public Defender's Office operate without you? Yeah, some of you may not know this, but I have been declared persona non grata by the Colorado Public Defender's Office. The statewide Public Defender's Office has written me a letter saying they will never work with me again. Even though the only time I ever worked with them, I did it for free, and I got their client acquitted of murder. Didn't charge him a penny. Gave expert testimony in court before the jury, provided an expert report, the whole thing, the whole 9 yards. My slides, my PowerPoint slides were used by the defense counsel in his closing argument to the jury. Didn't even ask me if he could do that, but it's fine. Got their client acquitted. And then they were so happy with me, they asked me to speak at their annual meeting, the Colorado Public Defender's Office annual meeting. Unfortunately, when I did that, I talked about some real crime events, and it happened that the perpetrators were black. And obviously I'm a racist. Oh, well. It made them mad enough that they sent me a 4-page typed single-spaced letter to tell me they would never work with me again. Yeah, Colorado, great riding in Colorado, southern Utah. The only problem, of course, is it's mountains. Is what makes it great riding, motorcycle riding. And because of that, you have a relatively short season. I mean, I've been caught in snow on the motorcycle in the mountain passes the last day of May. So you have June, July, August, September are pretty safe. And then in October, they start closing the passes for snow again. So it's really a 4-month riding season. You can ride in the winter up there. I've done it. I don't think I would do it again. It's sketchy. It's pretty sketchy riding a motorcycle in the Rockies in the winter. Mostly because the mountains are so high above the roadways that and the sun is so low in the winter that there's portions of the road that are never in sun. They're always shaded. So you really have to worry about black ice there. Yeah, Denver's gotten really dirty. Lots of homeless people, lots of crime. It's just terrible. Terrible. We're looking at the Franklin, Brentwood area south of Nashville. Yeah, so that's another part of the story. I did shows on this, but so the Public Defender's Office, part of their 4-page letter was when I spoke at their annual conference. By the way, they didn't pay me for that either. I booked the hotel and everything, and I all at my own expense, which is fine. I didn't expect them to pay. I don't have any complaints about that, but I'm just saying I gave all the representation was pro bono. I spoke at their conference at my own expense, and the only thing they gave me was when I left after the talk, they gave me a T-shirt. I guess they were giving all the speakers T-shirts. In their letter, their 4-page single-space typed letter, saying they would never work with me again, they demanded that I return the T-shirt. So of course, I obviously didn't do that. In fact, I raffled off the T-shirt and donated the money to a Second Amendment rights organization. I think we got $1,700 or $1,800 for that stupid T-shirt. We got a lot of money. I sent it all to a California-based Second Amendment Foundation. I forget which one, but a good one, one I'm personally familiar with, who does a lot of actual fighting in court and the Supreme Court for the Second Amendment with success. Let's see. Estes Park, Colorado. I was just in Estes last month. My in-laws celebrated their like 50th wedding anniversary or something there. We stayed at the Stanley Hotel. The Stanley Hotel in Estes Park, Colorado was the what's the word I'm looking for? The motivation, the incentive, that's not it. For Stephen King. Stephen King's The Shining book, and of course they made a movie out of it, where the guy goes crazy as he's wintering in this Colorado hotel. That the Stanley Hotel in Estes Park was the inspiration, is the word I'm looking for that, because it used to be closed all winter. It was only open during the the summer months. They didn't have like proper heating and stuff. It was built like 150 years ago. The Stanley Hotel, by the Stanley steamer guy, the guy who invented the steam-powered car. That's who built that hotel. So I stayed there a couple months ago. It was pretty. I rode through Rocky Mountain National Park. Rocky Mountain National Park's not the best riding in Colorado by any stretch of the imagination. And it's right next to Denver, so it tends to get a lot of tourists. There's better places to go in Colorado, but you need more time to get to those. Comment: possible conditional discharge is now being reported by the DUI guy. So Larry Foreman, the DUI guy, is in the courtroom. I don't know what possible means. Anything's possible. I guess he's there. He could be hearing stuff, but I don't know. Court will return at 1:45 p.m. Eastern time, that's in 15 minutes, folks. Let's see. Yeah, there is a general contact email at the on our website too, lawofselfdefense.com. So you might try that as well. Yeah, I really liked Franklin and Brentwood. It was very pretty country there. Really nice. We spent a week in Franklin, house shopping and school shopping. It was very pretty, and I got to say I missed the trees. So I spent most of my life in New England. You come out to Colorado, we're high desert here. There's no trees. It's literally like there's just scrub and stuff. The only trees where I live is where we plant them, and then you have to hook them up to your sprinkler system, or they just die. So and then you go back east of the Mississippi, and everything is so green, it's almost shocking. I can't really. I see people are trying to contact Emily. We do have a general contact email on the website. She'll get that. But I can't find this. Oh, Dan says he still hasn't gotten an email. He registered for the webinar twice. Just contact support at lawofselfdefense.com, and write that and ask them to forward it on to email and to Emily, and they'll do that. Don't keep registering though. You may be taking a new seat every time you register. I don't want one person to be tying up multiple seats. We'll get you fixed up. Even if we technically run out of seats, I'll make sure we have a seat for our members. Let's see. Brian says, "You're living my dream. I'd love to move to Franklin, Tennessee." I hope we do it. I'd like to be there and get settled down and start broadcasting from there. And it'll give me a chance to ride in the Appalachians again. It's been I haven't ridden the Appalachians since I moved west to Colorado. The riding there is it's very different than the Rocky Mountains for sure. It's good riding there. But their mountains are, we wouldn't call those mountains from Colorado. I mean, our mountains are 12,000, 13,000, 14,000 feet. The Appalachians, it's like 3,000 feet. It's not the same, but let's see. Yeah, if the trial is dismissed on this basis, I would suggest that there's grounds for the state to appeal the dismissal. This is a question of law. This is not a question of fact that's in the hands of the jury. It's not an acquittal. Even if the judge were to dismiss with prejudice, there's still grounds for appeal by the state. The biggest one would be that everything the defense is talking about is materially irrelevant to the criminal charge or any legal defenses. Let's see. Tail of the Dragon. I've ridden the Tail of the Dragon. I'm not a fan. I'm sorry. I mean, it would be great if there was no one else there, especially the law enforcement. But there's the East Coast is just so crowded. So many people go to Tail of the Dragon. A lot of them don't know how to ride. And there's so many crashes that the law enforcement presence tends to be intense. And the actual speed limit is really low. It's, if I recall, it's like 35 miles an hour. Very few people are riding 35 miles an hour. It's just not as much fun. But I've done it. I've got the, I want to say I've got the t-shirt. I don't actually have a t-shirt, but I've checked off that box. I prefer to ride where there's not so many people. Boop, boop, boop. All right. Any more super chats? Let me see. Where do these? I can't understand why I get super chats from all these foreign currencies. Like, I don't even know what that is. What the heck is that? I've never heard of that amount. I don't know anything about the law in other countries. Hungary. Oh my gosh. You only sent me $5 in Hungarian forint. Seems like he's getting a plea deal. Lawfare wins. I don't know. I have no idea what's going on in court. A plea deal has to be offered by the state. John says, as a veteran detective, I thought the two female detectives were inept, and Baldwin's attorneys are going to tear them up on the stand, especially the ex-Hooter detective. Yeah, I thought the officers here were largely not very competent. But I'm not sure that matters on any material fact here. For example, when they collected the gun at the scene, they didn't wear gloves when they collected the gun. Should you wear gloves? Sure. What are the consequences if you don't wear gloves? Well, you might be putting your own fingerprints on the gun. You might be putting your own DNA on the gun. You might be obliterating fingerprints or DNA that are already on the gun that matter. But whatever the consequences of that mishandling of the evidence, it doesn't go to any material fact in the case. There's no dispute that the gun was an Alec. Sorry, I'm looking at a picture of Adam. There's no material dispute that the gun was in Alec Baldwin's hand when it fired the shot that killed Halyna Hutchins. It doesn't matter whose DNA or fingerprints are found on it. So can you say they were incompetent in their collection of evidence, the gun? Sure, of course. But does it matter? It just doesn't matter. It's irrelevant to this particular case. Steve says, $10 super chat. Thank you very much, Steve. Steve says, even though I signed up to join the webinar on Sunday, I'm totally blind. Will everything be described auditorially if it's shown on the screen? Steve, I don't know what to tell you, my friend. I don't know how to do that. It's going to be, it's the show, the webinar will be presented, produced in the same manner we're doing things right now. So if that works for you, that's great. And if it doesn't, I'm sorry about that, but I don't know how to do this kind of content any other way. Brian says, $10 super chat. Thank you very much, Brian. says, I second you looking at the open fields doctrine cases. Here's some info to get you started on the one I'm familiar with. Oh, thanks. I'll take a look at that. Can I click on that? I guess I got to copy it. I'll copy it and send it to myself. So I have a... So I have a link there. Hungary. People from Hungary are watching this trial. That's hard to believe. Huh. All right. Let's see. Do a refresh there. Court should be starting back up again in just a few minutes. Hungary's back. Says, sorry, not good at freedom unit conversions. It's okay. I cut slack for the for all the foreign currency folks. $20 super chat. Dr. Kenneth, thank you. Says, thanks for all you do, Mr. Branca. I moved to Douglas County in 2003 during the Bill Owens administration. I've seen Colorado decline from a relatively freedom-loving state to a liberal cesspool. Can't blame you for leaving. Yeah, Douglas County is the county I live in, folks. I live in Castle Rock, Colorado. It's one of the larger cities in Douglas County. Douglas County, just south of Denver. Traditionally, one of the most conservative counties in Colorado. But it's, yep, the whole state's going sideways. So, time to go. Time to go. I saw the writing on the wall last couple of years. Now there's a supermajority of Democrats in the legislature. The governor is a Democrat. They've packed the state Supreme Court with liberals, and I can see the writing on the wall. Some of the major places I'll be in Canada during my trip is well, first of all, I'm going to stop in Montana and see my buddy Will Parker. Going to help him teach a course, a pistol course. Another good friend of mine, TC Fuller, is going to be teaching, hosted by Will. TC will be teaching a weekend shooting course up there. I think it's a one-day course, but he's teaching it twice. So I'll be a safety officer for the first time in like a decade. I'll be a safety officer just helping them out there. And from Will's place, I will cross the border into Canada, go up to by Revelstoke, Banff, Jasper, Kamloops, Kelowna. I apologize. I'm sure I'm mispronouncing these. Vancouver, and just kind of circle around that whole southern part of British Columbia before I head back through Yellowstone. I'll be spending a couple days in Yellowstone in the U.S., Glacier National Park. And yeah, I'm looking forward to it. It'll be good. Right after this trial. If this trial ever happens. Okay, let's see. Enormously long break. Note to self, enormously long break. The judge said about 10 minutes ago they'd be coming back in 15 minutes. Or rather, I saw, the judge didn't say that. I saw that displayed on the screen by Court TV. Let's see. Denver says, I would remain to fight in Colorado, but I think at this point, the tipping point is too far. I don't want to spend the rest of my life living. I spent 25 years in Massachusetts. That was enough anti-gun liberal politics for me. I don't want to live that way anymore. I don't have to live that way. I can live anywhere, given the nature of my work. So I just choose not to stay. Oh, Shane says to DM Larry, I'll try. Let me check out his Twitter. Let's see. Yeah, I'll just share Larry's Twitter feed here. And I presume, I'll send him a text. He's in the courtroom. Larry Foreman, the DUI guy, at the DUI guy plus on Twitter. Let's see if I can share this. Whoops, that's not what I wanted to share. That's silly. Let's do better, Andrew. Here we go. So during the break, I'm going to read these in reverse chronological order. During the break, Alec is having an extensive conversation with his family. Can't hear what he's saying. The prosecution's table is empty. Are they typing up paperwork for the defendant to sign? All the defendant attorneys are smiling and looking happy. Alec is telling jokes. One of the court people tells me she heard the words conditional discharge. That could mean that Alec may be taking a plea and he will serve no jail time and there will be some time on the shelf hanging over his head if he does not get in trouble for X number of months. So a deferment then all charges will be dismissed. This is standard in the defense world. Weird that he was originally offered that. Well, he was originally offered something similar. He was offered the same plea deal. During the break, Baldwin is seen talking to court personnel. He seems happy. Everyone at the defense table is smiling. Meanwhile, everyone at the prosecution table appears very tense. Alec and Hilaria just talked and kissed. Let's see. Corporal Hancock is sitting back at the prosecution's table. I think she'd taken the witness stand briefly. Are they not going to have her testify anymore? We're still waiting. Spiro asked to approach the bench again. Morrissey looks flustered as she speaks with him and the judge. This is from half an hour ago. We still cannot hear what they're saying. There's Hilaria and Alec hugging. That's Stephen Baldwin, Alec's brother behind him. Alec is sitting with his wife in the gallery. He's not taking his seat in the defendant's chair. Well, they're in recess, so it doesn't. The judge is sitting on the bench, waiting very patiently for whatever is happening outside the room with Alec and his wife and lawyers to culminate. Spiro has a very pleased look on his face. He's walking out of the courtroom once again. If Morrissey offered Alec Baldwin a deal with no jail time and he takes it, the jury trial will be over today. It'll be over forever if they make a deal. All right, well, maybe they're working out a deal. Judge is back 1 minute ago. Oh, we're back. Okay. Here we go.
Turn to the jury.
Volume just came up.
Caution them. Okay, all right, there you go, 1 o'clock, bye.
Oh, they're dismissing till 1 o'clock. No. And my lunch just came. Thank you, Emily. Hey, Emily, hold on a second. All right, so for those of you having trouble, all right, I'm on the air. Emily says if you're signing up for the webinar and you're not getting your confirmation emails, you may have unsubscribed from our email list. But if you contact support@lawofselfdefense.com, and we'll still do the recap on Sunday. I mean, we got it all scheduled now, regardless of what happens today. And we'll talk about what happened today. So, support@lawofselfdefense.com. You need to spell it out, lawofselfdefense.com. Back to the comments from the members. So now that's another hour and 10-minute break. That'll be the afternoon. I'm going to look at the comments here quickly, folks, and then I'm going to wrap this up as the morning show. And I'll come back at like 12:50 Mountain Time, 2:50 Eastern Time, in preparation for the court coming back into session. But what I'm hearing from Larry in his tweet is, let's see, did he respond to me in a DM? He just says, read my latest tweets. I did that. I suspect a plea deal has been signed. Zero confirmation yet. Okay, fair enough. Let him know. All right. So let's see. Comments. Bup. Well, the jury's not going to rule not guilty. I mean, the jury is not close to getting this case. So it would be a deal between the parties. And if there's a deal, Baldwin's pleading to something. Or it could be a dismissal for cause. But I don't think that's what's happening here. The judge would just do that. NBC is reported. Yeah, the judge sent the jury home until Monday. We saw that earlier. Oh, no, I'm not still muted, am I? Okay. Yeah, I was just talking to Emily for a moment. All right, one last look at Super Chats. And then I think it's the right time to take a break. Let's see. I'll take a look at oh, Brian says, yeah, he sent me a link earlier. Okay. And I'll take a look at Rumble Rants. I'm just looking for a bolded. Oh, that's it. Okay. Let's see. Is that not working right? All right, doesn't look like any Rumble Rant. So I'm going to go ahead and sign off, folks. Just remind you all about our Sunday recap. And if it turns out there's a deal and things have been dismissed, that's what we'll talk about on the Sunday recap. That's all. We're still going to give away $10,000 in prizes. And I'll still have Adam on. So that's where we are for the moment. And I will sign off now. And I'll just remind all of you that if you carry a gun, so you're hard to kill. That's why I carry a gun. So I'm hard to kill. So my family is hard to kill. The Sunday thing. Don't forget, you got to sign up for a seat. It's not on social media. It's a webinar. You have to sign up. It's free, but you have to sign up. lawofselfdefense.com/trial recap. If you carry a gun, so you're hard to kill. That's why I carry a gun. So I'm hard to kill. So my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law. So you're hard to convict as well. Until about an hour, 3 p.m. Eastern time, I'll see you all again. Until 10 minutes before then is when I'll go live. 10 minutes before 3 Eastern time. Until then, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.